My lord, this is a case of 212. Two times ABDB direction was made by this honorable court, but opposite party hasn't taken any action. Thereafter,
Why are you mentioning and what do you want?
because for restoration of this petition,
Restoration.
listing and restoration petition.
Today is not the day for mentioning. Yes.
My lord, may I have your lordship's kind leave to file and move
Microphone, please.
I'm sorry, my lord, the petitioner is the aged parents of a soldier who is also the highest gallantry award winner of our country. My lord, he was awarded posthumously, my lord. Now, my lord, petitioner is seeking apportionment of the family pension, my lord. They are not getting anything, my lord. If your lordship kindly consider.
Why the widow is there? A fight between the mother-in-law and the daughter-in-law.
Yeah, mother-in-law and daughter, parents, my lord, both. And only son, my lord.
Yes. And what does the law say?
Well, there is a provision in which it says that whoever gets the family pension will have an obligation to maintain all the dependents. Both of them are 100% dependents on their son, my lord. So, my lord, there is a provision for apportionment.
Yes, but then when did the son die?
My lord, in the year 2017, on 18.
17, all on a sudden, why?
No, my lord, it's pending for quite some time. He made a petition.
So why you won't leave? These matters are taken up on regular basis. You file it in the department, I'll see. File it in the department.
And one humble prayer, my lord. This matter was made returnable on 18th of March. It has not appeared in the list since. May it be included in the...
No, today is not the date for mentioning.
In the month of May, my lord. List of May month.
Come next time.
Application, my lord. Contempt application.
No mentioning for inclusion. My lord, contempt application. Nothing. Call the list.
My lord, I am for the respondent. I have mentioned the matter before your lordship. My lord, on the last occasion on 6th of April 2026, my lord has recorded that at para 5 of the order, learned advocate representing the respondent seeks time to revert with instruction as regarding to MMCC, claim of the petitioner. Para 6, report on this regard by the Eastern Coalfield shall be placed before this court on the adjourned dates. My lord, this matter, WPO number 532 of 2025, belongs to pension matter, my lord, not MMCC.
No,
Why
no,
did you mention MMCC?
no, my lord. This is a matter relating to the MMCC. Actually, what happened, my lord, before filing the writ petition in the original site, I have served the copy to the upon the respondent authorities. My lord, they have put the number. He has taken the number from the authority concerned. Authority wrongly put the number. Two matter was filed. 1531, that is the relating to the pension and gratuity, and 532 relating to the MMCC.
So 532 is MMCC.
532 is the MMCC. This is my repetition. Even your lordship's record, your lordship recorded that 532 is related to the MMCC. But my lord, wrongly, my lord.
Check up whether the number has been properly allotted or not.
That's why
your
your lordship
matter.
passed this order. I mean, your lordship's file is
Then it's
also
all right.
carry with the. But they have wrongly put their.
No order to be passed.
Madam.
Yes. But this has been converted. Has this been converted to
Yes.
the appellate side? ये के बोले दिन অনিমেষ বাবু এই ম্যাটারটা অ্যাপেলেট সাইডে হবে একটু Yes.
My lord, I am for the respondent number 1, Pradhan. This matter already been disposed of.
Pradhan? No, this is an original side matter. Where is the Pradhan coming?
No, my lord.
What is the name of the petitioner?
On 17 July,
What is the name of the petitioner?
Nirapada Maiti.
Sir, it original side, sir.
Original side. Oh, sir.
If my lord may kindly turns to the last order passed by your lordship on 2nd March, there was a direction to file a report in the form of affidavit, and that was your matter was made returnable yesterday, 16th April. No report has been filed. I am not getting either the contributory provident fund or pension. Pension I am not entitled to because it has been affirmed up to the honorable division bench. But so far as contributory provident fund is concerned, my lord, a liberty was given by the honorable division bench at the time of disposal of the appeal that I can apply before the court concerned, before the department concerned, and department will dispose of my application in accordance with law. And therefore, I made representation that was not been adhered to. So
yes, my lord, my report is ready. It is not affirmed. May I affirm and serve it?
Please come. On the prayer of the learned advocate representing West Bengal Transport Corporation. Come on, time to affirm the report stands extended till by next Wednesday. Can you do it? Today is Friday, 22nd. Released on 27th. Serve copy.
Exception, if any, my lord.
You want to?
I do not know whether if any.
Yes, that you do not know. In that case, returnable on 5th. Exception in the meantime.
Grateful, sir. Much obliged. My lord, this is
Well,
an
we have been
employee
on
of
the
the
state restaurant.
Calcutta State Transport Corporation. My lord, he retired on 28th February 2025. If my lord may kindly turns to the page 12. My lord, the name of the petitioner appears as serial number 2, page 12.
Prashanta Das.
Prashanta Das retired on 28th February 2025. If my lord may kindly turns to the next page, page 13. My lord, the Provident Fund was calculated around 16,53,201. That was not been paid
That has not been
till
paid.
date. Moreover, my lord, I am entitled to leave encashment up to 300 days. That is, there is a notification. My lord, I made representation for grant of the Provident Fund with interest at page 14. And I also made representation that you give me leave salary for the period of 300 days, which has been already been notified pursuant to the ROPA 2009. If my lord may kindly turns to the relevant page at page 21. Clause 9, bottom. The payment of encashment of unutilized leave, the recommendation of the pay commission shall be accepted. The employees of the corporation will encashment of leave up to 300 days, subject to the condition that the expenditure towards such enhancement of leave encashment benefit will be borne by the organization itself. The benefit of the encashment will be admissible to those who retired, will retire on or after 1st of April 2008. Since I retired in 2025, I am covered by this notification. My lord, in identical situation, my lord, I have annexed 2 orders of the coordinate benches granting leave salary for the period of 300 days, my lord, which your lordship will get at page 24. The relevant portion is at page 24, last paragraph. The petitioner's grievance is that, my lord has got it. The petitioner's grievance is that despite office order dated 17 September 2009, issued by the Joint Secretary Government of West Bengal to the Managing Director CSTC, holding the employees of the corporation will be entitled to leave encashment benefit of a maximum of 300 days. The employees of the CSTC got 180 days. I got 180 days. There is no doubt about it. But now, my lord, may kindly turns to next page, page 25, bottom. Now it is submitted by the state respondent that the Principal Secretary Transport Department, in consonance with the Principal Secretary Finance Department, Government of West Bengal, taken decision that the additional burden with regard to the leave enhancement benefits are existing 180 days to 300 days have to be borne by the CSTC. In case the petitioner is found eligible for payment of enhanced leave encashment benefit, the same shall be disbursed at the time of his retirement. I have retired, but that was in case of those who have not retired, or retirement of service in accordance with the extent ruler provision. The writ petition was disposed of. Well, identical stand has been taken by the honorable coordinate bench, which your lordship will get at page 27. The same thing, that the leave encashment should be of 300 days. And in this case, my lord, 180 days has been paid, and I am entitled to further remaining 120 days. Apart from the Provident Fund, which they have calculated, my lord, in the March 2025, just a month after my retirement, those has not been paid. I am entitled to with interest.
Provident Fund and the
Leave encashment
balance leave encashment.
Yes, ma'am.
Yes.
My lord, 2 prayers. My lord, he is entitled to both. My lord, as far as lordship has seen page 27, my lord, this is an offer, my lord, for the prayer concerning, my lord, the interregnum period between 180 days and 300 days. My lord, this is dated 7th of April. My lord, a similar order has also been passed by a coordinator between 16th of December. My lord, I am handing it over, but it is on the same lines. So, my lord, it is on the same lines. The judgeship ektu ekbar din.
What about the Provident Fund dues?
What can I submit? He is entitled to get it. I'll tell you, lordship, the main problem is the financial crunch.
I understand. But then
Paid, I tell you, lordship, not
these
paid.
are the service benefits.
I tell
You
you, lord,
cannot-
what happens is not paid, contempt filed, threat of rule being issued or rule being issued, state government releases funds, we pay. No, this is this position.
And by this, the state is incurring extra costs because
Absolutely.
interest is being paid.
Interest is being paid. Because, my lord, there are observations of your lordships also in other matters in contempt that ultimately, until and until released, upon rule being issued, my lord, we cannot pay. But ultimately, it is a burden on the public exchequer.
But
Please
contempt has become an order of the day. No order will be executed unless it has been carried up in contempt.
It's a type of a execution proceeding.
Yes, madam. It is a type of
In the civil code,
and
125 proceeding, all executions are to be filed. Now, this contempt is
now this
turned
has become an addendum to the main writ petition. A person has been made caution, you will have to go up in contempt.
The petitioner is a retired employee of Calcutta State Transport Corporation. Now it is the West Bengal Transport Corporation Limited, isn't
No,
it?
my lord, the Calcutta State Transport Corporation is distinct.
It's same.
Separate.
In page 15, I see representation to West Bengal Transport Corporation Limited. Why is it so? This is wrongly addressed.
Wrongly addressed, my lord. Formally, yes, my lord, wrongly addressed. Kindly ignore, my lord. Kindly take it into consideration. Calcutta State Transport Corporation.
State Transport Corporation. Stop. He retired from service on attaining his normal age of superannuation of 60 years on 28th of February 2025. Stop paragraph. His allegation is that his Provident Fund dues amounting to rupees 16,53,201 as calculated on 25th of March 2025 and his leave encashment for 120 days is due and pending. Stop. Paragraph. Learned advocate for the petitioner relies upon several orders passed by coordinate benches of this court in respect of similarly placed employees where direction was passed for releasing the dues of the employees within a stipulated time period. Stop. Prayer has been made to direct the authority to release the dues of the petitioner. Stop. Paragraph. Learned advocate representing the Transport Corporation fairly submits that the retired employee would be entitled to his terminal benefits. Stop. Paragraph. As it appears that the employer has already calculated the Provident Fund dues of the petitioner way back on 25th of March 2025 and admittedly the leave encashment for a period of 120 days is due, the authority would be legally bound to release the same in favor of the retired employee without any further delay. Stop. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the managing director of the there your cost title is also wrong. Calcutta State Transport Corporation to take steps for releasing the terminal dues of the petitioner, including the Provident Fund dues to the tune of rupees 16,53,201 and the leave encashment for 120 days at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. Paragraph. As the retired employee would be receiving his legal dues after a lapse of a considerable period of time, he would be entitled to receive the dues along with interest at the rate of, how much is it? 8% or something, the Chief
8%,
Justice,
6% in default 8%.
Chief Justice
So that has
fixed
been
it,
ultimately, my lord.
modified. अच्छा,
That was a different context.
क्या बोला? At the rate of, along with simple interest calculated at the rate of 6% per annum on and from the payable on and from the due date till the date of actual payment. Stop. If the dues of the petitioner are not cleared within the time limit stipulated herein above, comma, then the employer would be liable to pay additional interest of 2%. That is 6 plus 2 is equal to 8% on the due amount on and from the due date till the date of actual payment.
My lord, only one thing, my lord, subject to your lordship's pleasure. But as far as the, my lord, my lord, mandatory payment of the Provident Fund, my lord, I have nothing to say. But if your lordship sees, my lord, both the orders annexed in the writ petition and the order handed over by me. But with regard to the, my lord, interregnum of 100 and 300, my lord, both has been directed to be considered and passed.
But why considered? If
But
he is,
because, because I tell your lordship, he is entitled to. If he, but whether he comes under that bracket or not has to be ascertained. Because that ultimately, my lord, there is a notification which says
দেখুন
this.
তো, যেখানে বললাম না যে
My lord, he is entitled to the interest if he comes under that.
My lord, may kindly see the notification. It clearly
this
says.
is what I want to see.
Yes, my lord,
Page
kindly
17,
page 21.
page 21.
Yes, my lord, may kindly see clause 9.
No, it starts from page 17, isn't it?
Yes, but page 17 it starts from.
যেখানে
It
বললাম
includes
যে-
CSTC, CTC, and NBSTC. Notification includes.
No, they do not say that you are not entitled
correct.
because they have given 180 days. But thing is whether 300 days,
This 300 is his ultimate ceiling limit.
that is the maximum that you can get.
That's right.
But that,
Provided you have got 300 days leave to your credit, then only.
yes,
He can
that's
get one day less also. That is
Yes, provided you are eligible in terms of this. কি বললাম?
300 দিনই পাবে না 280 দিন পাবে সেইটা।
যেখানে বললাম যে 120 days পেমেন্টটা দেবে সেখানে লিখে দিন, provided the petitioner is found eligible not eligible, entitled to the same in terms of the revision of pay and allowances of the employees of CTC within bracket 1978 Limited. Being memo number 4090, page 17. This is the memo, please check.
yes, my lord.
Memo number 4090. Eta copy korben. Dated 17 September 2009. Disposed.
Yours.
But I beg to appear on behalf of the petitioner. My lord, the disciplinary authority and the appellate authority is the same. Nobody can be judge of his own cause. If my lord may kindly turns to that apart, there are other points my lord I'll be raising before lordship. Kindly see the appointment letter at page 50.
50
50.
2018.
2018, 16th of April 2018. But there was an engagement of a bus driver on contract. My lord may kindly see an appointment letter has been given by the deputy managing director. Now my lord may kindly turns to page 51. This is the order of termination, so-called termination, no disciplinary proceedings. That will be my second point. But whether the
51.
51, kindly see the last
2019.
line. Now in pursuance of the existing orders and rules in force, the undersigned terminate your service with immediate effect. They are signed by the deputy managing director. So he becomes the disciplinary authority. Now kindly see, because he has issued the charge sheet, show cause, no charge sheet. Now I made a representation in the nature of an appeal at page 45. An appeal for re-engagement in service as per rules of the corporation. But that was been addressed to both the managing director and a deputy managing director. The deputy managing director addressing to deputy managing director becomes superfluous because he has acted as a disciplinary authority. I have, in addition to it, I have referred to the letter to the managing director who becomes my appellate authority. Now kindly see the appeal, how the appeal has been disposed of, page 43. Now, 4 representation was sought to be disposed of on one order. Now, 12th of June 2023 is my appeal. There are other representations, but I have annexed, apart from 10th of February, I could not find out. I have not annexed. I have annexed 4th of February, 12th of June, that is the appeal, and 2nd of May 2025. This 12th of June appeal has been disposed of by the same person, the deputy managing director. Now, my natural justice has 2 facets. 1, nobody should be condemned unheard. 2, that nobody should be judge of his own cause. Now, the deputy managing director who acted as a disciplinary authority, he disposed of my appeal, although it was being addressed to a managing director as well as deputy managing director, that is erroneously addressed to. Now, the deputy managing director, he sat on his own order and disposed of my appeal, affirming the order. My error of jurisdiction, clear error of jurisdiction.
What was the requirement of a re-engagement?
But the re-engagement order is there. I will show to your lordship, there are in the leave rules, there is a provision that an employee, if he is discharged from service for unauthorized absence, on the first occasion he will be re-engaged with continuity in service. If he is again been discharged, he will be re-engaged without continuity. That will be a new service. And on the third occasion, if he is remain unauthorizedly absent, then he will be terminated. In this case, my lord, so far as this provision is concerned, my lord, the appeal ought to have been disposed of by the appellate authority. I would have all the opportunity to place the leave rules before the person concerned. I could have argued the matter before.
Show me the rule that you are relying upon.
My lord. Leave rules. Stands for my leave rules. Yes, I have annexed.
Page 30.
Yes, I have annexed. Page 37. It starts with the page 35. The relevant portion is page 37, clause 11. No, my lord. May I just. No, that is not the clause. কোথায় গেল? Excuse me, my lord. কোন জায়গাটা?
Is it there in the amended standing orders?
No, it is covered under the deep rules. It is covered under the deep rules, my lord. I had the occasion to place, but I could not find it out right now. But that apart, কোথায় গেল রে বাবা?
Come back in that case.
May I just?
My lord, I'll be willing to file an affidavit to this.
But that apart, my lord, I would be arguing, my lord, another one point, my lord. Since no opportunity of hearing has been given from show cause to direct termination, but the clause of the contract as well as the standing order has been violated. If my lord may kindly comes to
Where is the contract?
page 19.
90?
19.
Your contract?
Contract. It starts with page 16. My lord, it does not belong to the petitioner. Some other employees I have annexed with, but these are identical in nature.
All right.
If my lord may kindly comes to page 19, clause 9, any kind of misconduct, misdemeanor, minor or major offense on part of the bus driver as to be engaged on contract basis will invite disciplinary action. Definition of offenses, misdemeanor, misconducts on the part of the incumbent will be same as defined in the amended standing order of the company, in addition to those specifically mentioned in the terms and conditions of the engagement of a bus driver on contract basis. Disciplinary cases will be disposed of by the company officers in the prevailing disciplinary forum of the traffic department of the company. But now, vis-a-vis, if my lord may kindly turns to the, so it has to be done by the disciplinary authority. kindly comes to the standing order at page 22. It starts with at page 22. Now the relevant portion is at page 31. Chart sheet. Even in case of contractual employees, the same principles apply. Any employee, clause 13, any employee charged with major misdemeanors under these rules, except for continuous unauthorized absence for over 2 weeks, other than case of illness covered by the company's rules, shall receive a copy of such charge or charges and will be given every opportunity to revert the charge or charges. If, however, an employee evades receiving the charges, but that is the evasion clause is being there. Charge sheet will be displayed in the notice board. So I am entitled to the charges, and I am entitled to give every opportunity to rebut the charges. The opportunity of hearing should be given. But in identical cases, I have annexed 3 orders of your lordship's court, which your lordship will get at page 72 onwards. Wherein the identical case came up before for your lordship's consideration. If my lord may kindly comes to page 72. The petitioner was appointed as a bus conductor on contract, but I am on contract by the same organization. An agreement was entered into by the petitioner, but in this case also agreement was entered into. If my lord may kindly turns to page 73. Second paragraph. By a communication dated 17th April 2018 issued by the Deputy Managing Director of the company, the punishment of the termination was imposed upon the petitioner. In this case also direct termination. When appeal was preferred, which your lordship has recorded in. And lastly, if my lord may kindly turns to page 74. Second paragraph. The primary contention of the petitioner is that the capital punishment of termination of service has been imposed upon him without following the provisions and mentioned in the amended standing order of the company. The impugned order of the termination has been passed in violation of the principle of natural justice. The same is contrary to the direction laid down by the Honorable Supreme Court in the matter of Scooter India, and also in violation of the judgment passed by this court in matter of Calcutta Transport Company Limited and Procedural Mathur. The petitioner relies upon the instruction given by the General Manager Administration of the company to all the heads of the department and offices via communication dated 23rd May 2001 and 30th August 2003. The learned advocate refers to the order issued by the General Manager of the company, which says that the principle laid down in the judgment delivered by the bench of the Calcutta High Court presided over the Honorable Chief Justice on 1st August 2023 in FMA number 1256 of 2023. In the matter of Calcutta Transport Company Procedural Mathur hearing, the Honorable Supreme Court observed that the principle of giving an opportunity of hearing prior to an employee's discharge has to be strictly adhered to. Following that principle, your lordship was pleased to set aside the order. My lord has passed a recent order, my lord, big order, in view of the discussion, my page 79. In view of the discussions herein above, the impugned order of termination of service of the petitioner dated 17th April 2018 does not meet the test of fair play, equity, and natural justice. The same is accordingly set aside. The undated order of the managing director of the company passed in appeal. But in this case, appeal has not been disposed of by the person concerned. And at page 48, 41 of the writ petition also set aside. My lord, the identical stand has been taken, my lord, in page 80 by your lordship in case of Dinobandhu Rai, as well as in case of my lord at page 80, and in case of my lord another writ petitioner, which your lordship will get at page 91. The same stand, the notification which I have also annexed herein, the departmental order of 2001 as well as 2003, that you are imposing a capital punishment. You will have to adhere to the principles of natural justice and fair play. From show cause to direct termination.
Any appeal preferred against any of the orders that you relied?
Yes, yes. Appeal has been preferred, and your lordship was pleased
Not
to set aside.
statutory appeal, the mandamus appeal
No.
against these orders?
No appeal has been preferred.
And they complied with.
Yes. And they have directed to join. There was no de novo proceeding. Your lordship was directed that if required, you can start a de novo proceeding, but they have not started any de novo proceeding. They have directly given engagement. And out of the 3 orders that I have management, none have been carried up in appeal.
Yes.
It kindly comes to page number 43, my lord, as has been referred by the petitioner. My lord, may I just read page number 43? From your service record, it appears that you were terminated two times for unauthorized long absence, vide memo dated 20th 11 2016 and memo dated 6th April 2017, and also re-engaged two times, vide memo dated 6th February 2017 and 6th April 2018. Again, you have been absenting from duty since 26/4/2018. A show cause notice for unauthorized long absence were issued to you with a memo dated 21 January 2019. You did not appear. No reply has been received from your end. Accordingly, final termination for unauthorized long absence was issued with a memo dated such and such. It has been found from available record that you have submitted representations under reference for re-engagement, which is barred under the revised leave rules. Para 9A, re-engagement shall not be allowed for an employee after 2 cases of discharge. Retirement will be on medical ground for unauthorized absence. So, my lord, the principles of natural justice, it is not that they have not been complied. They have been complied. The petitioner
Where is this rule? Revised leave rules, please.
My lord, I'll have to come up with the revised leave rules and all the other. My lord, today I'm only on the conduct of the petitioner.
No, I can understand. He is continuously absenting from work and then joining. It becomes very difficult.
Even
for the
Shokas has
employer.
been issued to him.
And
He
he
has
did
not
not
replied.
reply.
He has been asked to come. He has not appeared before any of the authorities. Today he comes before the court and he says that he has not been.
I want to see your rules.
My lord, I shall bring the rules, and my lord, I shall. May I be permitted to file an affidavit, my lord, to this writ?
Please come. Where is the order of termination? Did you show it to me?
My lord, order of termination is at page
50,
51.
51. The petitioner was engaged as bus driver on contract by the West Bengal Transport Corporation Limited on 16th April 2018. Stop. His service has been terminated. On 3rd April 2019. Stop. The petitioner is aggrieved by the same. Stop. Violation of the principle of natural justice has been alleged. Stop. The representations filed against the order of termination stood rejected by the authority. Stop.
The same authority, my lord.
The petitioner alleges that there has been jurisdictional error on the part of the authority in passing the order of termination and rejecting the appeal preferred by the petitioner against the order of termination. Stop paragraph. Prayer has been made to direct the authority to permit the petitioner to join service by setting aside the impugned order of termination and the subsequent rejection of his appeal. Stop paragraph. Learned advocate representing the West Bengal Transport Corporation Limited seeks time to revert with an affidavit. Stop. It has been submitted that the petitioner was granted opportunity to reply to the show cause, which the petitioner failed to avail. Stop. he did not take any steps after 2019 and all on a sudden has approached this court by filing the instant writ petition in the year 2026. Paragraph. On a perusal of the impugned order of termination, it appears that the petitioner was found absenting on several occasions. Stop. He was permitted to rejoin twice, but on repetition of the same conduct, his service has been terminated in 2019. Stop. It will not be proper to direct the authority to allow the petitioner to join without granting any opportunity to the respondents to disclose their stand by way of an affidavit. Stop. Next. The respondents are directed to file their affidavits annexing all documents by, how soon can you do it?
My lord, 4 weeks is required.
All right, 4 weeks. Reply, if any, within a fortnight thereafter. List the matter for hearing on completion of the aforesaid time period.
Yes.
The last occasion, Lord, I made my submission. Today is the term of my West Bengal Transport Corporation, and Mr. Bihani, Lord, is appearing for
The
Calcutta.
Lordship had possibly directed the CSTC to be represented.
Yes, Lord. CSTC was added as a party in terms of.
That's
Yes.
Yeah.
There was no representation from CSTC.
Pursuant to
CSTC was not possibly implemented on the last occasion.
No, it has been impleted in terms of order of court.
yes, my lord.
That's right. Last occasion, we were not originally parties.
Not originally parties,
was
but
pre-
the implement also took place long ago.
Oh,
Yes, yes, and it was served.
yes, long back, 9th January 2024.
24. So,
But possibly the prayers are not directed against us.
that I do not know. I cannot remember also what exactly his submission
Promotional
was.
policy under challenge.
All right.
But on the last occasion, I placed the promotional policy with your lordship, and I have shown certain provisions. My lord, that is with your lordship.
They are all employees of the Calcutta Tramways Corporation.
Yes, initially.
Now observed in
Now West Bengal Transport.
West Bengal Transport Corporation.
From the common pool,
Yes.
the examination took place and then two different organizations. They claim similar benefit. Now, you possibly is the mother organization
No.
or the initial one. What is your role over here?
But possibly, my lord, what I have gathered, subject to your lordship's correction, possibly, my lord, lordship on the last occasion wanted to see, my lord, the promotional policy of the CST. So whether it is in sync or there is a difference.
Yes.
My lord, I have got the promotional policy.
My lord, the promotional policy was directed to me also to be provided. My lord, that I have asked for, that I have not received
They
yet.
are the
But
employees
however,
under them.
yes, but
Hmm.
however, my lord, I'll show from the petition, my lord, probably it is not required. I'll start my argument, but I'll place it, my lord, on the next occasion.
Lord, I'll be submitting, Lord. I have handed up the promotional policy of CTC Limited. Now, Lord, if my land friend wants to, Lord, rely upon the CSTC policy, Lord, let me also have a look on this, whether it is at par.
Relying on. Possibly it failed from your lordship to
The
have a look.
entirety of the case of the petitioner is the CSTC policy and CTC policy are in sync. That is why the petitioner
No.
wishes to, my lord, evade the process of examination which has
Lord,
been
kindly
done.
turns to page, possibly I have just gone, kindly turns to page 59.
Yes.
My lord, this is the notice inviting application by the West Bengal Transport Corporation.
Hmm.
Now, my lord, kindly see the eligibility criteria. Clause number 1 is 5 years experience in the post of clerk. Now, CSTC policy says 3 years experience from LDC to UDC. Possibly, if 3 years are concerned, they have a claim to be because they have been absorbed possibly lesser than 5 years. So that is the dichotomy possibly.
A few days,
Few
months,
4
or
years and
maybe.
5 years.
Yes, something.
But then,
Your
my lord, then I do not need separate organizations can have separate policies.
Certainly, absolutely. There is no issue with that.
My lord,
Let me see your policy and give a copy to him also if he wants to revert
Lord.
with looking.
yes, yes.
My lord, this is the policy. What I
But
am
one thing I'll tell you, Lordship, only one thing, my lord. My land friend has shown, my lord, the 5 years experience in the feeder post, and I have shown your lordship, my lord, the promotional policy of CTC. There, this 5 years is not mandatory. Your lordship will kindly look at that. In that case, also,
No, it is for the employer to decide what will be mandatory,
Yes,
what will be
quite,
optional,
quite,
what will be the promotional policy. It is their policy.
absolutely,
Why will
absolutely.
the
correct.
court
But
interfere?
I-
in
But that is
all this?
also not the case of the petitioner. The case of the petitioner is that I had appeared in one examination, I have gained a promotion through that examination. For the next examination, I need not appear. And I should be considered for promotion without having appeared in any of the examinations, because once I had been considered for promotion. And this is a very awkward stand to take.
Let me see your policy and give a copy to him also. Let him go through it and
Your
come back.
lordship kindly have a look at it starts from this last line at agenda 6. দাদা এটা একটু তুমি দেখো এখান থেকে শুরু হচ্ছে আবার ডিভিশন
তিন বছর তোমাদের 3 বছর
আমাদের এখানে হচ্ছে
That mandatory.
it is proposed to completed 3 years of service.
But is this the policy?
But this is mandatory.
Well, this is the policy.
This is the minutes of the
Pertain to
meeting.
minute. Well, till now I've been able to get my hands on this. But
Can this be taken to be a policy? I do not know. This is a
personally-
proposal.
I personally don't think so.
Yes, it
But
is
this,
the,
no,
as
this
in the
can be subjective.
proposal for filling up the
Well,
post.
This can be subjective. It is ratified later on.
But then something has to be there.
Yes.
There's a huge vacancy, UDCs and resolution approved filling of clerk. Yes. The corporation board approved filling up of the post from the feeder post of LDC, having 3 years completed service.
This is the proposal, and if your lordship sees this bottom at the bottom there, the resolution approves the proposal.
Yes, but it must be
In a form
in
of
line. Yes, in line with something. You just cannot
Right?
have a proposal and get it
Yes.
approved. That cannot be. Go through it
for
once
a
again.
5 years holiday. This is what I've been able to get my hands.
All right, you come back.
Lordship.
Please come. I won't keep this. You
Lordship.
better take it back.
আমি একটা ফটোকপি করে নিব না কিছু
আমি তোমার মেলটা বের করে দিই এটা করে কি লাভ হবে
হ্যাঁ এটা পড়ে কিছু লাভ হবে না অ্যাকচুয়ালি কোয়াইট সো
To allow the learned advocates representing the respective parties to revert with proper instruction, and particular the promotional policy.
Lordship.
Hearing of the matter stands adjourned. Stuff released on Friday, 24th. All right, 24th.
My lord, I'll not be there on 24th. My lord, 23rd is the election date. My lord, I'll be in my hometown.
ও আচ্ছা in that case my lord after 29 if at all
Hometown কোথায়?
6th of May.
Lordship.
Grateful, my lord.
6th.
6
Lordship.
না ঠিক আছে
Original set হয়ে গেল
Under 12 circumstances, I mentioned on matter, my lord, as to be mentioned, my lord, because your lordship, I handed over the report, my lord.
Xerox copy of the report filed by the state respondent. Your lordship directed your court officer, my lord, to hand over the Xerox copy, my lord. But unfortunately, I did not collect, my lord. After Xerox, my lord, it was sent to the department, my lord, man number section. So, my lord, to be mentioned to hand over that Xerox copy, my lord.
Can you not collect it from the learned advocate for the state?
They have Xerox it, my lord, along with the file, my lord, he send the same to the man number section, my lord.
Already give the number. Let me see what can be done.
Number one.
Para 3 of order dated 20th February 26.
Paragraph 3.
Yes, Lordship. Wrongly written. Type Lordship 26 November 99. But it will be 26 January 99.
The death certificate is annexed.
Yes, Lordship.
See what you have mentioned. এটা দেখান তো। এটা একটু দেখান ওনাকে। It has been done by looking at your copy. What have you mentioned?
Yes, Lordship. Sorry, Lordship. That's wrongly right.
Then it is for your mistake that this order has gone down wrongly.
Yes, Lordship. I'm tendering apology, Lordship,
But your apology is creating problem.
no, Lordship.
বুঝতে পেরেছেন? Death certificate. Again, you'll show something else.
Lordship, page 21.
26 January 99. Paragraph number 3. Yes.
My lord, this contempt matter, my lord, I believe has been disposed of by your lordship by an order dated.
Was it mentioned for non-prosecution?
Yes, my lord.
But my
Yes.
lord, the contempt matter has been disposed of on
Contempt-
17th of July 2025 by your lordship.
Let me check. What you want to not press?
Huh?
17th
My
of
lord,
July
one recalling
2025.
application was filed and therefore, my lord, at present,
Recalling,
my lord,
then my lord,
not
if
contempt.
any application is there after dismissal of contempt, then my lord, I'm not appearing.
Contempt is dismissed.
Yes, my lord, that
Dismissed,
is
therefore, my-
dismissed on 17th
Therefore,
of
my lord,
July.
recalling application was filed.
By
What-
whom?
For reviving
By
the-
whom?
by the petitioner.
This non-prosecution
Yes, my lord.
indicated, my lord.
What remains? Once it is
But
dismissed,
that
nothing
I don't
remains.
know, my lord. Why this is listed and indicated as non-prosecution? That is
Because
why.
that was mentioned.
Yes, my lord, I understand. But my lord, the
Applicant connection, but during the pendency, it is required to withdraw for filing fresh case with proper documents and proper drafting for effective adjudication of the instant case.
they both key research.
Just imagine how the litigants are taken for granted. A contempt is dismissed
My lord, by your lordship, yes.
on merits.
Yes.
No, my lord, it is not merit. But my lord, all the submission of my lord, on the submission of the state advocate,
Yes.
it is dismissed. My lord, it is
On
not
the submission, that means after hearing, after
my lord,
application
at
of the
that point
court's
of time-
mind, it was been dismissed.
point of time, due to my lord engagement in another court, my lord, I did not turn before your lordships, and therefore it is not properly submitted. My junior is here, and my lord, proper reply is not given to your lordship's query, and therefore it is.
And so you file an application for recalling of that order,
and therefore, my lord, recalling application was filed.
right?
And
And now
actually-
you say you don't want to proceed with the recalling because you want to file a fresh petition.
Yes, my lord.
The court already granted you liberty to file a fresh petition. You did not do that.
That is writ petition, not my lord the content. That is writ
After
petition.
dismissal of one contempt, court will give you liberty to file another contempt.
No.
Where from will all these new things are coming?
For reviving this contempt application, My lord.
Are you appearing for the applicant? Are you appearing for the applicant?
Yes, ma'am.
You are?
I am. My junior is Sukhdev.
Whoever, I do not want to know. Are you appearing for the applicant?
Yes.
You are representing?
Yes, my lord.
Very well. I'm going to dismiss it with costs and pay the cost.
Oh, my lord.
Till the cost is paid, I'll injunct you from moving the court with any further proceeding.
No, my lord.
What? No.
Please
come.
Only, my lord, kindly, not to give any, my lord, cost. Otherwise, my lord, the petitioner will
Contempt
suffer.
application.
Petitioner will suffer, my lord. And therefore, my lord, he is withdrawing this.
Stood dismissed upon hearing all the parties on 17th of July 2025. Stop. Despite dismissing the contempt application, the court granted. Now, the court kept it open for the petitioner to initiate appropriate proceeding for challenging the unauthorized construction made at the behest of the writ petitioner before the competent forum in accordance with law if so advised. Stop. The petitioner in the contempt application was the private respondent in the writ petition. The writ petition stopped. The writ petition stood dismissed, and the order of dismissal was affirmed by the Honorable Division Bench. Stop. After dismissal of the application for contempt, an application, a separate application being Can 1 of 2025 in connection with the contempt has been filed for recalling the order dated 17th July 2025. Stop. Learned advocate for the petitioner currently relies upon a communication made by the applicant Nirapada Maiti mentioning that he intends to withdraw the application for recalling, for filing fresh case with proper documents and proper drafting for effective adjudication. Stop. Paragraph. The conduct of the applicant cannot be appreciated by the court. Stop. Despite granting opportunity to the applicant to initiate fresh proceeding, the same was not availed of. Stop. Instead, an application for recalling the said order has been filed, and thereafter the same is being sought to be withdrawn. Stop. The private respondent appears to grossly abuse the process of law by filing one after another applications. Stop. The court is not permitting the applicant to withdraw the petition. No, the court will permit the applicant to withdraw the petition subject to payment of costs of rupees 5,000 to be paid by the applicant to the SLSA Juvenile Justice
Lord, I am
Fund.
apologizing, my lord, on behalf of the petitioner, my lord. My lord, it is filed
By-
wrongly, my lord. Therefore, my lord, it is
By-
withdrawn. My lord,
17.
kindly,
24th April.
my lord, kindly,
Stop.
release
In the event costs is not paid by the said date, comma, the application of the petitioner now is not paid within the now we'll end the cartoon. Release the matter once again on 28th of April 2026 to a certain payment of costs. Stop. Till the costs are paid, comma, the applicant Nirapada Maiti will not be allowed to file any further petition challenging the unauthorized construction
my lord, by Monday, my lord,
complained of.
he will deposit, my lord, by Monday.
Very well. You come back. I give you more time.
Kindly,
I
make it
give you
on
more
Monday.
time.
Kindly make it on Monday, my lord.
No. Next.
Kindly make it on Monday, my lord. Otherwise, my lord, the petitioner will suffer, my lord. He is a very poor person, but he will suffer. Kindly make it on Monday. Kindly make it on Monday, my lord.
Next.
Lord, I appear on behalf of the Lord.
I am for the question, Lordship. So I am saying unconditional apology, Lordship. If there is any mistake in the order, Lordship, on my part, Lordship.
Wait, what is to be corrected?
Lordship, para 3, the father of the petitioner retired.
Retired?
Yes, Lordship.
Not died in harness?
No, no, Lordship.
Very well. Show it to her. Please show.
Yes. For which, Lordship, I am praying unconditional apology.
Now I'll start imposing costs. Or I have to disbelieve the learned advocates who come before the court.
No, Lordship.
The court relies upon the advocate
Yes, Lordship.
because you all are the officers of the court.
For
But
which,
if
Lordship,
this
I am
is the
praying
thing that is
unconditional
coming,
apology, Lordship, on my part, if there is any mistake, Lordship. But petitioner is right, Lordship. Para 3 I have stated and I have annexed the Lordship death certificate.
what will it be? Not died in harness?
No, Lordship. First retired, thereafter died. Retired on 30th April 2001.
14th April 2005, the date is mentioned. This is also wrong.
Date of death, Lordship.
Died on.
Yes, Lordship.
Not died in harness, but died on.
See, and Lordship.
On the date following death of retired on the land quickie. When did he retire?
Retired 30th April 2001.
30th April 2001. And died?
Died was 14th April 2005.
করে দিন আমি দেখবো paragraph number 3 father of the petitioners এইটুকুনি শুধু retired on এত তারিখে and died on এত তারিখে
Lordship, page 3, Lordship.
paragraph 3
Page 3 orders.
page 3 again all
Line, Lordship, 8. From the date of retirement in place of death, Lordship.
from the date following the date of retirement.
Grateful, Lordship.
Before I appear for the petition, Lord, I appear on behalf of the state respondents, so that I have been directed to file a report in the form of an affidavit, my lord. This is a report, my lord, and copy of which has already been served to my learned
All
friend.
right, what is the matter?
This is regarding the transfer of health assistant female. Your lordship, kindly have a look to the order once. But the recent order of Ranu Hajra, up to that, your lordship has seen. Thereafter, the transfer orders in compliance of the Ranu Hajra's order, had been passed. Your Lordship, kindly have a look to the transfer order 148 onwards. My Lord has seen in many cases. 156 health assistant females had been transferred pursuant to the order of Ranu Hajra. The recent order is at page 145.
What is the challenge?
Now, we have not been released because only in the district of Murshidabad, the health assistant females who had been transferred to their home district, they had not been released. All other districts have complied the order passed by the director. He is the highest authority. Only the CMH of the Murshidabad, he is not releasing the petitioners. Now, that is why there is an administrative anarchy. The director
Administrative
anarchy. The director is the supreme authority. He passed the order of transfer. He pursuant to that order, all the release orders have been passed. Kindly have a look to the other release orders. I have annexed.
page?
157 to 162. 157 to 162. 157. It has been passed by the Nodia CMOH. Got it?
Yes.
Then 158, South 24 Pargana CMOH. All of them have mentioned pursuant to the order of the Director of Health Service dated
released.
11th of December 2025. My Lord, got it? The following health assistant females have been released. Page 157 also, same thing written. Then 160. This is Nondigram. Pursuant to the order of the health director.
This page 146 is the reasoned order in Ranu Hajra.
Yes.
Right? Were you a petitioner over there?
Yes, yes. All the petitioners are there.
Were parties?
Yes, yes. They were the first petitioners.
All right.
And Justice Rai Chattopadhyay's order is also there, page 142. Pursuant to, in compliance of which.
What is the stand taken in the affidavit?
But the stand taken in the affidavit is, kindly have a look to the affidavit once.
Yes.
The CMOH Murshidabad has filed this affidavit and say that they have not completed 3 years, which your Lordship has negated in the case of Dolly Rajbongshi. Yesterday, but I have.
But then this was in Ranu Hajra itself, the director himself permitted the order of transfer.
Because my Lord has found in the order of Dolly Rajbongshi that this order is in directorate nature. Kindly have a look to my Lord's order once.
Show me which portion in the affidavit. Thus, 3 years of completion of service is a must for getting inter-district transfer. Then,
Lord, kindly takes me, Lord. It is my affidavit, Lord.
Yes,
Kindly takes me, Lord. Page 11 of my Lord affidavit. Does your Lordship got it, Lord?
Yes, yes.
Lord, this is the transfer guideline. Lord, circular is there. Lord, point number 3. After completion of 3 years of uninterrupted and satisfactory service, health assistant is eligible for intra-district transfer, inter-district transfer subject to the availability of the vacancy. But if your Lordship takes trouble to read page 146, this is the reasoned order. Kindly comes to sixth paragraph, fifth and sixth paragraph, sentence start and whereas. It appears that the applicants have claimed that they have been transferred to the district other than their respective home districts, with number of vacancies unfulfilling in their home district. But the fact of the matter is that during the creation of any such order of posting, only the obligation of maintaining overall balance of requirement of health assistant employees in different districts of West Bengal with public interest is kept under consideration. Therefore, and whereas it appears that the petitioners moved to this honorable court with their grievance of not getting posted in their home districts, but in accordance with clause 3, the clause 3 your Lordship just read. Clause 3 contained in the order of Director of Health Service such as such said, they are eligible for any inter-district or inter-district transfer only after completion of 3 years. Only after completion of 3 years of uninterrupted and satisfactory service
subject to availability of vacancy in the concerned districts. Now kindly says, takes page 147, that is in order. Now therefore the undersigned, has your lordship got it, that portion will order? Now therefore the undersigned, after going through the entire facts of the case, have observed that the petitioners are desperately desired to get home district or nearby district posting. But the fact remains that being the head of the West Bengal Nursing Service under Department of Health and Family Government of West Bengal, it has become a real challenge. This is very important, to maintain overall balance of requirement of health assistant employees in different districts of West Bengal and the demand of the petitioner. The department has to consider public interest first and foremost at the time of preparation of posting order. There is huge disparity between the vacancy and immediate requirement of assistance for that matter. It may happen that there are few vacancies in some districts, but need instant posting order of health assistant as they are unattended. In the above backdrop, although it was felt that the petitioners are facing much difficulty in their place of posting, which is far away from their home district, then too, this department has no other alternative but to persist with the existing order. At the same time, it is assured that the administrative department would consider the case of the petitioner as much as practicable when the next batch of health assistants would get their posting. So, two things have been emerging. Public interest as first and foremost, and thereafter they have to keep overall balance. And if your lordship kindly take vis-a-vis my affidavit. Paragraph 8 onwards, I have stated the actual state of affairs. I state that the 54 health assistants, your lordship has seen the 54 health assistants names, were in the transfer order dated such and such, were expecting to get relievers when the newly appointed health assistant were joining the district, but only in 8 such sub-centers out of 54 sub-centers have joined at their sub-centers. In remaining sub-centers, no reliever from new batch joined. The newcomers joined in other vacant sub-centers. Again, in those 8 sub-centers only where relievers have joined, as they have also not completed 3 years of service in the district, they could not be released for. I stated the health assistants are posted in sub-centers in different rural blocks. But this is very vital. The role of health assistant is extremely important, as she is main team lead for a sub-center in giving immunization, maternal and child health services, and family planning services, other services in the sub-center. It is extremely important that relievers are posted in the sub-center so that health assistant under transfer order can get released. As without any health assistant in the sub-center, it is extremely difficult to give patient care and mother and child health care services, rural setup, and maintain continuity of service. Apart from that, your lordship has seen, at the time of they took the appointment, they knew it's a transferable job, and transfer is the incident of service, and they can be transferred anywhere. But in this instance, also, they are not fulfilling 3 years of eligibility criteria, and also, it's a transferable job, they know. Their posting, cannot be registered on the ground of, personal difficulty. And, public interest is, involved. And unless and until, we get the sufficient number of relievers in each sub-center, we cannot release them. But
the government notification,
we have to keep in also mind, 3 years of service they have to complete. 3 years of continuous and uninterrupted service. But if we have to give effect of the transfer order, then you have to violate our own transfer guideline. And that too, we have to get sufficient number of health assistants as relievers.
May I reply to this?
But unless and until we get the relievers, we cannot release them.
Where from will you get the relievers? It is you who have to arrange for relievers.
Yes.
Relievers will not come from outside.
No, that process has already been done, Paragraph 2, if your lordship kindly sees, paragraph 2 and 4. Paragraph 4, precisely.
And how soon are you expecting the relievers to join?
Kindly,
the next batch has joined.
4. Yes,
has joined?
Yes, the Dolly Rajput is the next batch.
Paragraph 4.
Just how the order has been given to your lordship. I will reply to this.
Paragraph 4. That is transfer order.
Out of 54 staff awaiting transfer, only 8 got relievers.
Yes, although no time limit has been mentioned in this particular order under reference. When this transfer order was issued by state, another order was issued simultaneously when newly appointed health assistants were given postings in districts. Against the order of 94 health assistants joined in different vacant subcenters existing at that time in this district. Newly joined staff act as relievers for staff awaiting transfer. At that time, there was a vacancy of 249 health assistants female in the district, that is Murshidabad. That means 249 subcenters did not have any health assistant.
Is it right now also 249 sub-centers do not have health assistants?
Yes. Lord, it was affirmed on, Lord, 24th March of 2026.
Yes.
Yes.
There is no health assistant
Yes.
in respect of
Because
249.
kindly see the second line, only in the each sub-centers under this particular transfer order, relievers have joined from the fresh batch. Thus out of 54 staff awaiting transfer, only 8 got relievers. But none have completed 3 years of service. So they could not be transferred.
That is the case.
But if we allow them to give the release, my lord, if we release them, then, my lord, we would violate our own transfer guidelines.
No, but the director who is your superior authority, he has mentioned just now you read out to consider the case of the petitioners as much as practicable when the next batch of the health assistants will get the order of posting. Now the next batch has joined already.
Yes.
So why don't you relieve them?
My lord, until and unless we get the relievers, my lord, in each sub-center, my lord, we cannot.
You do not have relievers?
No. That's why, my lord, paragraph 4 and 6 says.
Why are you not engaging health assistants?
That process has just begun, my lord. Kindly gives me my lord, some time so that I can get back to your lordship and, my lord.
Without relievers, you cannot be relieved. Where are the relievers? Otherwise, the sub-centers will not.
May I reply to this? Well, first of all, if your lordship kindly takes up page 11 of the report, the only point that my learned friend is coming up with 3 years of service. The first is 3 years of service. This 29 January 2024 circular has been taken care of by your lordship in case of Dolly Rajbanshi. Yes. Now, the interesting part is, just now I have handed over one order dated 25th of February 2026 in case of Alisha Rahman. Malad got it? Yes. Here also, Malad, she was appointed in 156 candidates. But I moved that petition before Justice Rai Chattopadhyay. Paragraph 8, what the Honorable Court has said. She also prayed for Malad release.
The 25th of February is a different order.
No. Alisha Rahman, WPA 1641. Yes. She also prayed for Malad transfer to her home district. Kindly have a look. The present petition is entertained, placing so-and-so. The petitioner is working as female health assistant, Murshidabad, who has been transferred by order dated 11 December 25. Then, she has been appointed from Murshidabad to Kuch Bihar. This order just now I have relied. Grievance of the petitioner is that in spite of issuance of the transfer order dated 11 December till date, she has not been released. Then, petitioner paid for a direction upon the concerned respondent authorities to release her as per transfer order dated so-and-so. Then, in the meantime, last paragraph, in the meantime, the respondent authorities shall be at liberty to release the petitioner, which would permit the petitioner to join the transferred post in terms of the transfer order dated 11 December 2025. The court has granted this petitioner the relief, but in my case, the court has sought for report. Very well, I have no problem. But if this order has been complied with and the transfer has been effected, then why we will not? Because in the case of Dolly Rajbanshi, your lordship is aware that I have shown 814 vacancies have been filled up. Fresh candidates.
You tell me whether there are relievers.
May I come back on Monday?
That you can.
Monday I have some difficulty, my lord.
Tuesday.
All right, I'll give you some other date. But thing is,
I will take
sub-centers cannot be
I've
left
understood.
unattended under
I've
any
understood.
cost. It has to run.
Very well. Kindly fix a date for Tuesday. I will come back with the instruction.
Report in the form of affidavit
Just
filed by the Chief Medical Officer, Murshidabad. In court today be written with the records. Stop. It appears therefrom that the petitioners cannot be relieved despite issuance of the order of transfer, as the relievers, as out of 54 staff awaiting transfer, comma, only 8 got relievers. Stop. In the absence of the relievers, comma, the subcenters cannot function. Stop. Learned advocate representing the petitioners seeks to revert with instruction. Stop. On such prayer, released on when? Next week?
Friend, Tuesday? I have no problem.
21st will be all right?
Because 4
21st.
months have gone after passing.
21st.
21st. And by this time, 8 may be released because 8 had got the reliever, according to the report.
Acha. Pendency of the writ petition will not stand in the way of the authority to release the A&M.
Health assistant female.
Acha, health
assistant female.
Page 4.
A&M. Health assistant female. Provided relievers are available.
Grateful. Great. Grateful.
For the Union of India. My lord, this is that matter, my lord. The petitioner before your lordship is the development officer of the LICI.
Oh,
And my lord, he has been issued with the show cause. And my lord, another rule, which is my lord under challenge in this writ petition as well. And it
you
has,
said similar order can be passed as was done in the earlier matter?
yes, my lord. May I just take your lordship objection, my lord, to the order?
You had the objection on the last occasion also, the maintainability of the writ petition?
No, this is not on maintainability. This is not.
Some
on
other
maintainability.
objection?
Yes. The objection is that, my lord, they are praying for a similar order passed by a coordinate bench. Now, my lord is hearing this matter for the first time after Allahabad Division Bench has taken an independent view and upheld the constitutional validity of 2009 rules. Now, my lord, on this proposition, I'll just want to place, my lord may take my lord's view, my lord, I want to place 3 small judgments with 3 small paragraphs. What the Supreme Court has to say.
What is your objection?
My objection is that this interim order cannot be passed because the Honorable Supreme Court is clear on a point that when the issue is pending before the Honorable Supreme Court, this writ cannot be touched. If the writ cannot be touched, with deepest of respect, my lord, no order can also be passed. That is one of the proposition I want to show. The second proposition that I want to show is that when a constitutional court has already upheld the constitutional validity of a rule and has upheld it to be intra-virus, it is applicable upon the other constitutional courts as well. And the third one, which I want to show, is that when a rule has been challenged, it is the court who has the presumption has to be that the rule is intra-virus. Otherwise, else if the court has to pass an order, court has to give an explanation to that effect. These are the 3 propositions I want to show, and very small judgment. Thereafter, my lord may decide.
Before my learned friend, my lord, places your lordship the judgments. My lord, the inception of the argument of my learned friend is that before after the order that has been passed by this honorable court, there has been a new circumstances that has evolved. That is absolutely wrong, my lord.
All right, you tell me one thing. This you have challenged the 2009 rules over here?
Yes.
The amended rules of 2016 also you've challenged?
And my lord, just one more submission, my lord. My learned friend.
And my lord, I expected that he will be, my lord, addressing your lordship that he has already taken this point before the honorable coordinate bench that has been turned down.
That I'm saying.
Everything,
That was my
he just
first submission.
Started, my lord, showing
Before
to
my
your
lord,
lordship.
before my lord, this is the first time this issue. Maybe a coordinate
Not at all
bench has
first time.
not.
Not at all.
Maybe the coordinate bench has
Not
not
at all.
taken an independent view. That does not bars this court from taking another view, my lord, because
So you want the court to spend time on an issue which has been decided for the time
no,
being.
my lord, with the best of
For
respect,
the time
issue has
being.
not been decided.
All right,
None
some
of the
order was passed, it was carried in appeal, and the appeal
Yes.
court did not interfere.
Yes,
in it.
here I want to come, my lord. Kindly see, my learned friend should have shown that order, that order perhaps, which my learned friend is indicating, by our division bench is of 3rd of September 2024.
Yes.
Now, at that particular juncture, this division bench of Allahabad High Court, which came in December 2024, was not placed. Obviously, that judgment was not
happened.
So, our division bench did not have the occasion to deal with this judgment. Now, the scenario has
How
changed.
are you prejudiced by this order? Will you please say?
Well, no, obviously, we are prejudiced because the constitutional court has already upheld the virus, and they have.
Oh, 1 minute. Prior to you moving further, it's upheld and not ED added to it.
Well, it has upheld it.
Upheld, not ED. Uphold, upheld.
Now, my lord, the question remains, they being aggrieved has preferred an appeal before the Honorable Supreme Court. Supreme Court has consciously not granted any stay over that order. So if the Honorable Supreme Court has not granted any stay over this order stands as on date. And in terms of the 3 propositions which I submitted and I will be placing, my lord, this order is binding upon all the other constitutional court. My lord, kindly seize just
I will decide that.
Now, my
Let
lord,
the court
with deepest
decide.
of respect, my
Till
lord,
the
kindly
time,
consider
let this interim order
one
remain.
judgment, that whether when this issue is pending, whether the other court can, just one, my lord, paragraph 83, one small paragraph. What the Supreme Court has to say, my lord, 1986 supplementary Supreme Court cases 20, paragraph 83, my lord. That the writ cannot be touched. If the writ cannot be touched, then no interim order can be passed. My lord, may I just the last page,
yes.
83 civil appeal such and such are directed against an order of the Gujarat High Court dismissing writ petition filed by the appellant challenging the constitutionality of section such and such of Mines Act and the validity of notification dated such and such, and directing the appellants to approach the Supreme Court as similar matters were pending there. In our opinion, the course adopted by the High Court was not correct. If the High Court thought that the point raised by the appellant was same as was pending in this court, it ought to have stayed the hearing of the writ petition until the court disposed of the other matters. So, my lord, stayed the hand. If that is the direction, then, my lord, with deepest of respect, this writ cannot be touched. If the writ cannot be touched, no interim order can be passed. Now, my lord, this is one of the proposition. Another one, my lord, thereafter, my lord, decides. I'll not, my lord, one judge, just 2 paragraphs. All are small judgments, my lord. This is reported in 2004-6 SCC 254, para 21 and 22. I'll just put it up. Yes. May I just? Para 21 and 22, small, my lord. A parliamentary legislation, when it receives the assent of the President of India and is published in official gazette, unless specifically excluded, will apply to the entire territory of India. If passing of a legislation gives rise to a cause of action, a writ petition questioning the constitutionality thereof can be filed in any high court of the country. It is not so done because a cause of action will arise only when the provision of the act or some of them were implemented shall give rise to civil or evil consequences to the petitioner. A writ court, it is well settled, would not determine the constitutional question in a vacuum. the court must have the requisite territorial jurisdiction. Now, my lord, an order passed on a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view of the provisions contained in clause 2 of the Article 226 of Constitution of India, will have the effect throughout the territory of India, subject of course of the applicability of the act. So, my lord, if a constitutional court of Allahabad High Court has upheld the validity of this rule, it will have the effect all over the country. And my lord, with deepest of respect, that order has not been stayed, my lord. I'll just put this order, my lord, at my lord's leisure. I don't know whether this division bench order has been placed or not, para 76. Clearly, they have upheld the validity. Where the question comes for any interim order, when the Honorable Supreme Court has not protected them or stayed the operation of this order.
Which
para
paragraph?
76. Just, my lord, three paragraphs. May I just please? In view of the above, we are unable to see the development officers as just another class of employees of the LIC with no intelligible differentia. Intelligible reasons for the differentia exist as the LICI preserves and is expressed by way of a policy, a disciplinary module to be applied to development officer to generate new business. Per se, the module of assigning 40 agents who work on commission paid by the LIC to each of the development officer with a minimum target to generate enough new business to defray the annual remuneration paid to the development officer with further provision for payment of bonus to the volume of new business generated by the development officer above the threshold limit in any appraisal year, clearly indicate the intent of the policy to keep the development officer motivated and encouraged to generate more business for the LIC, as may allow for the high profitability to exist. Thus, reasonable nexus exists between the mode adopted and the purpose sought to be achieved. To the extent, it may never be denied that every commercial corporation, including LIC, exists for commercial reasons and not for philanthropic or non-profit activities. And further, insofar as it is undisputed to the petitioner that LIC as a corporation is lawfully entitled to earn maximum profits, the intelligible differentia clearly exists to distinguish the petitioner/development officer as a class apart from other employees of LIC based on the difference of work and its impact on the existence and growth of LIC as a commercial corporation besides its overall profitability. As noted above, the impugned rules work in a measured way. It first prescribes the cost ratio, expense limit, and eligible premium, and then provides for evaluation of a development officer on whose factor at the end of a reasonable length of time, namely 12 calendar month, that is appraisal year. Even at the stage of appraisal, it prescribes uppercut of beyond the expense limit that may not be breached by an individual development officer. Even in the event of such limit being breached, the rule first introduced a scheme of disincentive. When those fails either over a longer period of time or they fail hopelessly for 2 consecutive years, the consequence of termination may arise. To that extent, a reasonable nexus clearly exists and has been applied and enforced through the rules between the object, which is to increase the profitability and not to allow complacency and inefficiency to settle, as may hinder the growth of LIC as a profit-making commercial entity. There is no invalidity in the rules. As noted above, there is no manifest arbitrariness in the rules. As discussed above, they are wholly reasonable in measure and in application. Not only they apply the principle of natural justice, but also incorporate valid reason such as accident or illness suffered as a ground to not enforce the consequence of termination. It may be noted here itself, those grounds do not exist in any of the present writ petition. Thus, the action taken by LICI is in accordance with it. As to the submission of disproportionality, we are equally not impressed. Once we have found that the rules are valid, reasoned, and measured, the issue of disproportionality of the action does not arise. Thus, in the entirety of the facts and circumstances of the case, the rules provide for additional disciplinary measure for development officer in addition to the general disciplinary measure provided under the staff regulation. In view of intelligible differentia and reasonable nexus exists, there cannot arise any further objection to the validity of the rules for reasons of those being incorporated separately. To the extent we find that the rules are wholly valid in law, further submission based on Part 3 of Constitution with respect to the alleged premature termination must be rejected in that line. For the reason we do not find any infirmity in the rules, all the writ petition lacks merit and accordingly dismiss, no order as to cost. So, my lord, the Honorable Division Bench of the Allahabad High Court has clearly upheld the validity of this rule and has passed a judgment of 77 pages. The Honorable Supreme Court has consciously not granted any order of stay over the operation. All other honorable high courts of our country has accepted this. It is just that with deepest of respect, our high court is not accepting it. And however, definitely it may not accept. But my lord, for such reason, there has to be a reasoning to that effect.
Yes.
So, my lord,
this order was passed on 2024.
My lord, I'll just.
Yes, 20th of December 2024.
Now, my lord, kindly see our division bench order. It is perhaps on 3rd of September 2024, which is prior to that. So, it was not possible. Obviously, this judgment was not there at that particular juncture when our division bench has considered.
And in the interregnum, no order has been passed by this court.
Only the coordinate benches order, all saying just only one issue, my lord. None of them has decided with deepest of respect, my lord, only saying that the Honorable Supreme Court, the issue is pending. Now, my lord, if that is the view that our High Court have to take, then, my lord, 1986 supplementary comes into the play.
Supreme Court did not stay the order. Where is it?
Yes, my lord. Supreme Court orders. My lord, I'll just handle.
Is the petitioner aware of this order of the
everyone is aware. Everyone.
The Honorable Court is our. If I just could please, after his.
You let him finish.
My lord, from here, my lord, backside, all the Supreme Court's orders are there. On the backside, my lord, the last order is on the front page. My lord would see the name of
Hitesh Kumar Goel was there.
Kumar Goel, my lord, his name will find on the second page here. Hitesh Kumar.
Right, yes.
So Hitesh Kumar Goel preferred the.
Mm-hmm. (21st of April is the next date.
Yes. And my lord may see all the orders. No stay has been even asked for.
So, all right, yes.
My lord, about this order, my lord, of the Honorable Division Bench of the Allahabad High Court, that is passed back in 2024. Thereafter, my lord, there have been several interim orders that have been passed by this Honorable Court in the Honorables before the Honorable Single Benches, including this Honorable Court. My lord, they did not prefer any appeal or anything of that sort. But, my lord, yes, my lord, they preferred an appeal against one of such orders. And that appeal, my lord, was withdrawn by them. And thereafter, my lord, they preferred an application for vacating, which they did not press till date.
No.
My lord,
not make.
Wait, just wait, yes.
So that division bench, by the Honorable Division Bench, my lord, the appeal, my lord, was withdrawn by them. And thereafter, my lord, they preferred one vacating application before the Honorable Coordinate Bench, which they did not press.
All right.
Now, my lord, what happens here? But if I just could take it, because it has fallen from your lordship whether but before any of the Honorable Coordinate Benches, this order was placed. Kindly see this once. This once. Internal page 4.
Mhm. Mhm. Mm. It has recorded that the
Exactly.
stay prayed for has not been refused.
Yes.
Has not
My
been
lord,
refused.
now I'm
Hmm.
asking this question to myself, my lord, whether they have preferred any appeal against
Yes, my
these
lord.
orders
My lord, may I?
and whether they have obtained any stay against
My-
these orders.
Just an appeal was preferred.
Now they have
and
been
when
just
they-
making this up,
No, my
submissions,
lord,
my
my
lord,
lord, my lord.
and they have been
an
demanding.
appeal
May
was
I complete
preferred.
and thereafter he will be submitted. My lord, and they have been demanding from this honorable court before the honorable division, the honorable single benches to pass different orders in the same matters. While all these matters are being taken up together.
I'm
Instead
submitting
of
to
making
a
any
court to make a independent view. If a coordinate bench has not taken an Indian, that does not bars this honorable court from taking another view.
and lordship, the order that has handed up to your lordship by this honorable court, my lord, that also, my lord, they have not,
My lord,
preferred
may
any
I
appeal
just may
or any application for vacating of that sort. And most
My lord,
unfortunately, in all these
appeal-
matters, they did
One
not.
minute, please show me your show cause.
My lord, your lordship will
My
see.
lord, prior to that, my lord, before my lord goes in, kindly
19th of
take the division bench
February.
order.
My lord,
Because-
page number, my lord, 146. My lord, the next page would be, my lord, my reply to this.
Page number 146, does it contain a date?
Yes, my lord, at the bottom.
My lord,
Oh, left-hand side bottom, 19th of February 2026. You filed your reply.
yes, my lord, next page.
Any consideration? Not yet.
My lord, the consideration that they do is, my lord, issue the termination letter.
There is nothing in between.
No, yes, my lord. There is no stage in between. So this is what
No,
is
my
the
lord,
challenge.
my lord, the rule.
One minute, one page show cause with a 15-page reply
Yes.
response.
Yes, ma'am. My entire allegations, why, my lord, the cost ratio that they are asking for, why that could not be met. Because there are several points, my lord, that I have raised in my reply as well. That different policies of the.
Please come.
This is on merit.
My lord, just one moment, my lord, the division bench order, because that one two-pager order, my lord, may kindly consider this thing. And appeal was preferred. When the appeal was preferred, my lord, before our Honorable Chief Justice was taking up this appeal, at that point of time, my lord, the Honorable Chief Justice has himself has indicated that why we have not shown Kusum Ignat's judgment before the learned single judge. On this aspect, my lord, the appeal was withdrawn with the liberty to file a modification application. That modification application is now pending. Now, my lord, may I just place from paragraph 3, it's a short judgment order. During the course of hearing, may I just, my lord?
1 minute. 4 remains, 5 remains. A show cause notice has been issued against him on such and such date. The petitioner is aggrieved by the same. It has been submitted. This will remain. This also remains. Take down 11. The petitioner has already filed his reply to the show cause, which is yet to be considered by the authority. Stop. Prayer has been made for passing an interim order, restraining the authority from passing any final order till the disposal of the instant writ petition. Stop. The aforesaid submission of the petitioner, submission and prayer of the petitioner is opposed by the learned counsel representing the Life Insurance Corporation of India. Stop. It has been submitted that the issue in question has been decided by the Honorable Division Bench of the Allahabad High Court on 20th of December 2024 in a batch of writ petitions, first of which is writ A number.
Citation is given here.
Such and such, name of the parties, neutral citation number, such and such. Wherein the court was pleased to uphold the impugned rules. Stop. It has been submitted that the appeal preferred therefrom is fixed for consideration before the Honorable Supreme Court on 21st of April 2026. Stop. It has been submitted that as the issue has been decided by the division bench of a constitutional court of the country, the same will be binding upon this court. Stop. Next. I have heard the submissions made on behalf of both the parties. Stop. ওইটা বলার পর এটাকে নিয়ে আসবেন। The issue has to be decided upon exchange of affidavits. তারপরে এফিডেভিটের ডিরেকশনটা হলো, মানে এর মাঝখানেতে it appears that the petitioner has already responded to the show cause issued by LICI, it will be open for the respondents to consider the same in accordance with law. Stuff. Let the reasoned order by the Life Insurance Corporation of India be placed on record by the authority as and when the same is passed. Stuff. It will be open for the petitioner to apply for obtaining interim order in the event any punitive or coercive step is taken by the LICI upon consideration of his reply to the show cause.
But if the order for termination is passed, my lord,
Come back. That will be a fresh cause of action, but then I have
taken effect on the very date itself.
I can understand, but then seeing
That
this.
means, my lord, could I just pray only one thing? But if any coercive order is passed against the incumbent, my lord, let that not be, my lord, given effect to within 7 days at least, so that I can just take the breathing time.
Provision.
May I make my submission? Thereafter, you will be saying.
There is a provision for appeal before the chairperson, my lord. They never do that.
All right, let them.
At least, my lord, may I just get a breathing time of 7 days? So within, if the coercive order is passed.
Assuming you are terminated, you can always approach this court. This is open to you.
Can you appreciate if the
it will be open to you? No, because since it has been decided, you cannot show any order where after Seeing the division bench's order, the matter has been decided on merit by any court. For this,
Well,
a hearing is to be done.
By the Honorable Coordinate Bench, that has been decided. Lordship has seen.
No,
No, not decided as such.
There is an interim order passed by which he is protected now. But
No.
my lord must be protected by this, my lord.
No. You come back. 21st is the date before the Honorable Supreme Court. I do not know what will happen on the
But at least I
21st.
just could get, my lord, a breathing time for 3 days. Lordship will kindly appreciate, because otherwise, my lord, my entire writ petition will be in flux.
You come back. No.
I'm so grateful.
Yes, next.
As your lordship.
Time item number 6, I'm led by Mr. Shane, who's appearing virtually.
Well, I appear on behalf of state.
But the order of Dolly Rajbongshi I have annexed here. Page 166.
My lord, may I tell one thing, lordship? My lord, every time, my lord, the petitioners, my lord, who are these, my lord, the female, my lord, the candidates,
Health assistant.
Health assistant. Now, my lord, every time, my lord, they're coming and my lord, they are, my lord, showing that my lord's particular order, and each and every time. Now, my lord, I have heard, my lord, item number 4, where it appears that apart from that circular, my lord, that another practical question is with regard to that the reliever.
Yes.
Because otherwise, my lord, all these centers, sub-center cannot function. And another thing, lordship, kindly consider, after going through the writ petition and the annexure with regard to representation, whether my lord would, my lord, still, my lord, will entertain the same, because of the fact it appears from annexure P3, my lord, at page number 132, that the representation made by the 8 writ petitioners on, my lord, 31st of March 2026, and the writ petition affirmed on the same day on 31st of March 2026. And in paragraph number 10, it has been averred, or the averment has been made, that the representation has not yet been considered. Now, this type of writ petition, whether lordship, my lord, should be entertained or
Which page? 1 minute. Which page? P3? Which page is P3?
Representation 132.
132.
And
yes,
then, my lord,
31st of March.
Yes, and then, my lord, the others candidates representation, my lord,
And
followed
these representations are sent by mail, and the writ petition is affirmed
on 31st of March.
Same date.
Same
Yes.
date.
Why will the writ petition be entertained?
My lord, the answer is there in page 168 of your lordship's order.
Yes.
Paragraph 15. Each of the writ petitioners will forward a separate application.
No, that does not mean that relying upon one order, you will come to the writ petition, to the writ court by showing that I have filed representation. Sorry.
Your
No entertaining at all. Not
the
at all.
averment itself is incorrect at
Then,
paragraph number 10.
kindly allow me to withdraw with the liberty to file afresh, because otherwise, my lord, it will hamper the fate of the petitioners.
Nothing doing. You have chosen this path.
My lord, may I?
This is not proper.
Only, no. My lord, if my lord, they are not at fault, it is my fault. I take it on my part.
My
lord, your lordship, kindly allow me to withdraw it.
10 health assistant within bracket female.
Yes.
Have approached this court alleging that the representation filed by them has not been considered by the authority. Stop. The representation appears to have been forwarded via electronic mail on 31st of March 2026, and the writ petition has been affirmed on the same date. Stop. The conduct of the petitioners clearly mentioning that the respondents did not consider the representation does not the allegation of the petitioner that the respondents did not consider the representation does not appear to be proper. Stop. The petitioners have not given the minimum time to the respondent authority to consider the representation allegedly filed by them. Stop. Next. In view of the above, the Writ petition cannot be entertained. The same stands dismissed.
But kindly keep
Service
that
is
liberty,
taken on
my lord,
record.
so that my lord, we can approach
What
afresh.
liberty?
My lord, yeah, by this time, my lord,
It will be open for the Likanito, it will be open for the respondent to consider the representation filed by the petitioner in accordance with law.
grateful.
Next.
Great.
Get.
For the petition. Very candidly, when I said that I have not mentioned for release of the matter for made a prayer for assignment. Yesterday, I have taken my instruction from my client that the matter has been mentioned by one learned advocate Alan Felix. ফোন করেছিলাম ওনাকে অ্যালেন ফেলিক্স বলছে আমি আমার মধ্যে করিনি
So, bother to place you did not mention?
No. But I have personally contacted to my learned advocate, Mr. Alan Felix.
The honorable judge has recorded.
Lordship, I have seen.
Think that the court is going to disbelieve.
My lord, I have seen, my lord, yesterday, my lord, the order passed by my lord.
Then?
I have personally contacted my lord, the learned advocate.
Yes.
He told me that he mentioned his matter, not my matters. Mistakenly, the matter was my lord, released.
Anyway, now it has been released and it has been assigned. Do you want to place? You do not want to place? Is the other side present? Who are you representing? Who are you representing? Who are you representing?
For the state, man.
The Joynagar Mojilpur municipality is to be served.
I have served.
No, make further service. The matter has been assigned before this court by the Honorable Chief Justice. Stop. Let notice be served upon the respondents. Release the matter on 4th May. Yes, service is taken on record.
Grateful, Lords.
Director's matter.
8 and 9, I am for the alleged contempt.
My lord, there is a written instruction, ultimately that they are not willing to proceed with the matter.
Too much of pressure upon them.
Presently, my lord, for my instruction, works are going on.
Not at all. The
respect of the present this petitioner's application.
My lord, and so far.
Why are you making it only to the petitioner's application, restricting it? The condition is not proper.
That, my lord, I don't have any instruction.
You will not have instruction. But the court can understand what is happening. And not only the court, it is there before the world to see what is happening. And why should the petitioner, she's fought to this extent, and why she wants to withdraw right now?
We have received the mail at 10:19, my lord, today. February 17th, April 17, 10:19. That she wants to withdraw this application, the one which I've handed over.
I can understand.
And so far as the next matter is concerned, my lord, item number 9, we have been verbally instructed that he is also not willing to proceed with the matter.
What happened to that? Nothing happened possibly. There was a direction for...
There was a direction, my lord. Thereafter,
upon the principal secretary and everything.
There was
hearing took
and
place.
The report was also filed before your lordship.
Yes.
State had filed.
State had filed a report,
yes.
my lord. Thereafter, my lord, there was
nothing.
No response.
The principal secretary also failed to...
yes, my lord. To a certain extent, he had tried his level best because on one occasion, I had attended the hearing along with others, my lord. I believe you.
I was also present, my lord, in the hearing. I was also present, my lord, in that hearing.
Why don't you extend your good offices and see things can be resolved?
And now, before for the ensuing election.
Principal secretary was there, my lord, at that point of time. He tried to resolve.
Principal secretary is something different. The client is yours. Principal secretary's client is not there.
That is true.
Then why is all these things happening? I am not permitting to withdraw. Take steps.
In view of the ensuing election, my lord.
I'll adjourn it.
In June then, my lord.
All right. Hearing of the application stands adjourned till 15th of June. I'm not passing any order. It's expected. Actually, it is expected that the authorities involved in the film industry, or what this is? Film and television industry.
On this, there are two groups, my lord. One is the Assistant Directors Guild as well as the Federation of Senior Technicians. My lord, the contemnants.
Yes.
And here, my lord, it is the film directors are the individual, my lord, petitioners. There were 14 petitions initially and 2 contempt.
Film and television industry. Ensures that the petitioners are able to work freely, strictly in line with Articles 19(1) within bracket G, Articles 19 and 21 of the Constitution. This is only a broad indication. Articles 19 and 21 should not be infringed upon.
Mainly 19, ma'am.
Yes. And 21 follows.
Grateful.
Same order in 9.
9.
My lord, item number 10, I am for the petitioner. My lord, petitioner. Yes. My lord, it is a case of denial of promotion due to pendency of 498A case. Though, my lord, I was entitled to be promoted after 3 years. I was appointed in Holdia Dock Complex as lower division clerk in 2016. Thereafter, 2019, my lord, page.
You are for the Union of India?
Yes.
Holdia Dock Complex?
My lord, 2019. My lord,
What about the 498 case? Is it pending?
My lord, I have exonerated.
You have been exonerated?
Yes, but my lord,
a sealed cover procedure was followed.
Nothing, my lord. Even my lord, as per the notification, OM, my lord, 22,000 something,
Yes.
ad hoc promotion was required to be given, but no ad hoc promotion was given. And my lord, the point is, my lord, that framing of charge was later when in 2023, but I was entitled to be promoted in 2022, September 2022.
And when did the promotion actually take place?
My lord, that is during pendency of this writ petition. In my lord, 2025, I gave the promotion, and thereafter, when I made the representation that I want to take the promotion from 2022, and during pendency, I cannot accept that.
They cannot. They did not consider.
And they did not consider, and they say that it will be subject to the pending, my lord. Since you have already raised the issue before the Honorable High Court at Kolkata by filing a writ application, which is pending before the Honorable High Court for decision, this office refrains from making any comments on the issue.
Who is the authority writing that letter? The senior deputy manager. Your representation is before
yes,
the
my lord,
senior deputy
manager, P and IR division. And my lord,
waiting for consideration.
All right, please come. The petitioner's prayer for grant of promotion with retrospective effect.
Yes.
Is pending consideration before the senior deputy manager within bracket P and IR, Holdia Dock Complex for a considerable period of time. Stop paragraph. Learned advocate for the petitioner submits that the petitioner has been acquitted in the criminal case which was pending against him. Stop. The subject case was no way related with his service, and the pendency of the said case ought not to be a reason for not granting promotion to the petitioner. Stop paragraph. As it appears that the prayer of the petitioner for grant of promotion with retrospective effect is pending consideration before the authority, accordingly, the court is not inclined to pass any order in this matter at this stage, save and except directing the senior deputy manager within bracket P and IR being the respondent number 4 herein to consider and dispose of the petitioner's prayer strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken by the authority without any further delay.
My lord, may I?
A reasoned order shall be passed and communicated to the petitioner.
My lord, I have made several representations from 2022. They are not considering it without any court of law. My lord, they will not give it.
This is the court's order.
My lord, they will not, my lord, consider. Let the writ petition be kept pending, my lord. My lord, because they have given it from, my lord, 2025. My lord,
Our representation is for giving it from retrospective effect.
2022.
Actual leave is granted. The learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents to the aforesaid authority at the time of communicating the order of the court.
Next. Already representation is annexed in the writ petition.
Yes,
85.
you give that with the court's order and everything. Next.
My lord, it is the affidavit of service.
Yes, Levin. Yes.
My lord, actually he was working, he was in person doing, but
Who was doing in person? Petitioner?
petitioner.
Now you will be representing.
I will be present.
All right. Has Wakalatnama been executed?
They will be, he will be doing it, my lord. So,
Today, my lord, the Vakalatnama was filed on the department.
It has been filed. All right. Yes.
well, this is only a very little question. He's an employee in the railways.
What is your prayer?
Here is this position has not been given. Six TPC, he has not got it. But
He's not got the benefit under the 6 CPC.
The petitioner has received
sixth.
Not given, my lord. I am the petitioner, my lord. My lord,
If the learned advocate is there, why will you appear? You have executed Wakalatnama? Have you executed Wakalatnama?
not given, I am appearing in person in my own case.
তাহলে আপনি ওনাকে এনগেজ করেছেন আপনি আবার নিজে দাম পাচ্ছেন
Who has given you the Wakalatnama? Are you aware who your client is?
ওই ম্যাটারটাই Yes,
Shailesh, please check.
According,
you have given the Wakalatnama.
আপনি করবেন না রবীন্দ্র করবেন
What is your name? What is your name?
My name is Tamal Mukhopadhyay. Well, today is filed.
I can see your Wakalatnama has been filed today.
Yes, my lord. My senior has been.
কে করবে আপনি করবেন না
But who executed the Wakalatnama? The petitioner is here in person.
আপনি যদি করেন করে দিন আমার
তো করছি
পেমেন্ট
তো।
করেনি
আমি তো সেটাই
accordingly I hereby
Mr. Mazumdar,
Huh?
the petitioner is here in person and he says he has not executed Wakalatnama in favor of anybody. How can the Wakalatnama come?
আমি তো কোনো দেইনি কোনো গিয়ে
Now an investigation has to be caused.
My lord, it is not university.
Let the Wakalatnama be placed before this court. Bring the Wakalatnama. The petitioner appears in person and submits that he has not executed Wakalatnama in favor of any learned
My
advocate.
lord, I have no objection if he.
There is no question of any objection. Have you executed Wakalatnama in favor of?
Signed as Wakalatnama.
He has not signed. ঠিক আছে? Learned advocate. Mr. Tamal Mukhopadhyay.
Lord, he has been signed, my lord. I have instructed from my senior that he has been signed the Wakalatnama. That's why I am appearing, my lord. I am filed by the clerk on the department, my lord.
Yes.
Lord, on Tuesday, my lord.
Led by Mr. R.N. Mozumdar. Appears on behalf of the petitioner and submits that Wakalatnama has been executed by the petitioner and the same has been filed in the department today, that is 17th April 2026. Stop. Let the Wakalatnama be placed before this court. কতক্ষণ লাগবে আসতে? কতক্ষণ? বেশিক্ষণ লাগবে না? সেকেন্ড হাফে নিলে হয়ে যাবে? 2 o'clock, please come. I'll bring the Wakalatnama. You please wait. 2 o'clock, I'll take up your matter.
Yes.
All right? Yes.
My lord, today 2 p.m. we have a fifth matter.
Sir, let your junior come. I want to see at least the Wakalatnama, whether it has been signed, whether it has not been signed, who is going to appear. All right?
Yes, my lord,
Let your junior remain.
she is also there.
No, you go there, she'll be here.
But if the hearing is taken up on merit, my lord, kindly take this matter on Monday.
Monday, I will not be here. Then I will be put there Monday.
Just wait, you finish and come. Let her remain. Call the next matter. হ্যাঁ ধরে রাখুন যদি চলে আসে Wakalatnama তাহলে দরকার নেই আনিয়ে নিন Why did you not take instruction? Let me hear what he has to say.
Lord, the petitioner were suspended with effect from last January 2025. 2025, Lord, more than 1 year. On account of, on the allegation of that they have been involved in recruitment scandal. Recruitment of constables, CRPF.
Oh, recruitment scam. Yes.
And they are extending from time to time, but nothing.
Suspension order.
Yes, my lord. More than 13 months, my lord.
13 months?
Yes, my lord.
All right. Let him come with instruction. Please come.
In the meantime, let there be a stay.
Let there be?
Stay of the inquiry proceeding.
Inquiry proceeding. The inquiry is continuing. Why will it be stayed?
My lord, more than 13 months.
Let us see. What is the fate?
Your lordship.
The petitioners are serving as members of CRPF. Stop. They have been suspended. Where is the show cause?
Page 20, my lord.
Page 20.
20. Office order.
By an office order dated 10th January 2025. As they have been found to be involved in malpractices in recruitment of constable / GD 2024 during DME / RME at the recruitment center at CAPS GC Durgapur. Stop. Paragraph. It has been submitted that the alleged inquiry is continuing for more than 13 months and there has been no development. Stop. Prayer has been made to set aside the order of suspension and to direct the authority to permit the petitioners to join service. Stop. Next. Learned advocate representing the respondents seeks time to revert with instruction. Stop. Paragraph. The allegation against the petitioners is such that the court is unable to that the court is not convinced to pass any interim order in this matter. Stop. The respondents are directed to file a report by way of affidavit disclosing all facts and figures within a period of 6 weeks. Exception, if any, may be filed within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
Or may I pray for shortening of the time?
Don't, please do not pray. The vacations are coming. How can it be shortened? Please come. Next matter, please.
Minister, I am appearing for the petitioner.
Yes.
I think the matter which my lords have heard just now, it is more or less same. I do not know. Respondent counsel may inform. Because I am challenging the order of suspension. My order of suspension is dated, page 13 P1. It is date 28th of January 2025. And thereafter, the departmental proceeding has been initiated. Memo of charge has been served to me after 5 months from the date of my suspension order. And still, I am under suspension. And it is January 2025 is the original order of suspension. Page 13, if my lords will be pleased to see. P1, page 13.
Did you serve the writ petition upon the respondents?
Yes, Miss.
When was it served?
Sir, my assisting counsel is there, Miss.
Yes. Was any notice of upgradation given?
This notice has been served to the respondents, Miss.
Where is the notice of upgradation?
My advocate on record must be there, Miss.
Yes. Let me see once. Please come.
It is the same matter which was
Same
argued
order
just now.
Same order. The order date is 28th of January 2025.
Yes.
Right. None appears for the respondents. Let this order be communicated to the respondents immediately.
But just now I have received instruction to appear on behalf of the Union of India.
Oh, in that case, the same order will go down. Order dated. Service is taken on record.
Miss, may I request that a date be fixed if possible, Miss?
No, I have given the time for filing affidavits and then liberty to mention. Please come back.
I'm so grateful.
Yes, next.
May it please your lordship. I beg to appear for the petitioner, my lord. My lord, this matter, my lord, this writ petition has been instituted by the petitioner on the ground that, my lord, in spite of their issuance of a transfer order, my lord, she has not been released from her current post, my lord. My lord, this matter earlier was moved before my lord Justice Sugata Mujumdar when his lordship was pleased to pass the order whereby liberty.
What is the date of the order?
My lord, the date of the order is 25th of February 2026, my lord.
Yes.
My lord, if your lordship kindly takes up the third paragraph, my lord, the petitioner is working as
1 minute. What is your reply?
Kindly come to my lord. Page 3.
Give a copy to him.
11 and 12.
Give a copy to him.
Yes. Page 3 paragraph. And then
Page 3 paragraph 12.
No, 11. 11 and 12, man. Then my lord 9. 11 and 12.
Why?
And then my 9. then 9. This is the main thing, Lord.
No reliever is there is one ground, but you say that you'll start a DP against her, then communicate it to her.
My
Have
lord,
you
we
communicated?
have already filed an application before the SAT, my lord. Prayer D. Prayer D. My lord, there are 4 show cause, prayer D of the petition. Show cause has been issued, my lord. Show cause has been challenged, my lord. My lord, that application is lying pending before the SAT, my lord.
Then that's different.
My lord, my lord, in my lord, collateral to their allegation, my lord, I have raised allegations, my lord, of harassment, my lord. No proceeding has been initiated on the basis of that allegation of mine, my lord. But that issue is a separate issue which to be dealt with, my lord,
It is
separately.
not a separate issue. Your order of transfer has been kept in abeyance, and that is the main issue.
My lord, if I may apprise your lordship, my lord, after the issuance of the show cause, my lord, thereafter, my lord, the reason order was passed. Thereafter, my lord, the transfer order was issued, my lord. My lord, deemedly, they have.
The petitioner is serving as health assistant within bracket female. Stop. Her allegation is that she has not been released from her place of posting despite issuance of an order of transfer. Stop paragraph. Prayer has been made to direct the respondents to issue the order of transfer immediately. Stop next. Upon perusal of the instruction forwarded by the Chief Medical Officer of Health, Murshidabad, signed on 11th of March 2026, it appears that there are multiple complaints against the petitioner of gross negligence of duty, leading to gross hampering of mother and child health service in the area. Stop. An e-file has been initiated and sent to the Director of Health Service, West Bengal, for starting departmental proceeding against her. Stop. A request has been forwarded to keep her transfer in abeyance till the disciplinary proceeding is completed. Stop. Paragraph.
Let me take an exception to the file, an exception to this report, my lord.
The report paragraph further mentions that there is that the petitioner is posted in Chanda
Chachanda 2.
Roman 2 subcenter, Shamsherganj. Stop. No reliever has been engaged in that place. Stop. The health assistant cannot be. Now, the function of the health assistant is extremely important, as she is the main team lead in the subcenter for providing immunization, maternal and child health services and family planning services, apart from other services in the subcenter. Stop. Without a reliever, an health assistant cannot be released, or else the public interest will suffer. Stop. Paragraph. It appears that the petitioner has already challenged the decision of the authority to initiate departmental proceeding against her, and the matter is pending before the matter is reportedly pending before the West Bengal State Administrative Tribunal in OA number.
Has been annexed, my lord, at page number 141, my lord. Page number 141.
OA number 629 of 2025.
My lord, there is no quorum functioning, my lord. That's why.
Take steps to proceed with that.
My lord,
I'll say
pursuant to
next.
the order, my lord.
As the as it appears that the petitioner is already facing a departmental proceeding and her order of transfer has been requested to be kept in abeyance. Accordingly, the prayer of the petitioner for relieving her in terms of the order of transfer cannot be accepted. Stop. It will be open for the petitioner to proceed with her application before the competent forum for challenging the departmental proceeding initiated against her.
My lord, only.
Stop.
My lord, if I may beseech your lordship, my lord, if your lordship kindly grant us liberty to take an exception to this report, my lord.
What
And
can I
let me-
do with the,
my
what
lord-
will
my
the
lord,
court
if I may,
decide?
My lord,
Your main issue is the DP.
no, my lord.
Did
What
petition dismissed.
my lord, my submission, my lord, contention was, my lord, that by this transfer order, my lord, they have themselves negated their show cause order, which they have. If your lordship kindly keeps it pending, and my lord,
Next. 15.
My lord, in this matter, I am for the petition only. My lord, what happened in this matter, my lord? Sir, affidavit of service to the.
Yes.
Affidavit of service. My lord,
Service.
petitioner before your lordships, my lord, was an ex-employee, grade 3 of the Food Corporation of India. My lord, he was appointed in 1978, and all along, my lord, he was tendering his service up to 2007, my lord. In the year of 2007, my lord, suddenly he was transferred from Calcutta to Siliguri.
1 minute. What is your prayer? Cancelling the order of deduction as taxable interest from
Your
the
lordship
Provident Fund.
kindly see, my lord. Kindly see annexure. Page 23, my lord. Your lordship kindly see.
Yes.
My lord, your lordship kindly see in the middle taxable interest.
Yes.
My lord, my provident fund amount was, my lord, calculated 11 lakhs 45,444. My lord, from this amount, my lord, they have deducted 3 lakhs 59,223 as interest. Taxable interest. My lord, according to Income Tax Act, my lord, section 1011 of the Income Tax Act, my lord, interest accrued on the accumulation amount of provident fund is tax free. No tax can be.
Non-taxable. Show me that provision.
It is not required at all.
What?
We have not deducted.
Not deducted?
Deducted. Given reply. Suppress that in the petition.
Where is reply? Where is reply?
This is the reply. My lord, I am giving a copy to him. First
That means no deduction will be
no
made.
deduction has been
Yes,
made.
my lord. I will show you.
Please stop. If he says there will be no deduction, why are you saying that
Well,
there will be
first paragraph.
deduction?
First paragraph.
I mentioned that has not been deducted from the CPF. This amount is interest income earned by the on his CPF balance beyond the date of retirement, which is supposed to be. This amount is interest income earned by the member on his CPF balance beyond the date of retirement, which is supposed to be deducted in his total taxable after retirement while filing the income tax return.
But
No amount has been deducted.
I am just explaining.
Yes.
He retired on October 2009. His total CPF accumulation was 7,86,414.
Where from are you reading?
Page 19. Page 19.
Page 19.
19. I have today calculated.
Huh.
You kindly see.
Yes.
Up to first paragraph. 31
lakh.
Corporation's contribution 43 lakhs.
No, not 43 lakh. It's 4 lakh.
4 lakhs. Sorry. 4
3 lakh 16,000 is the corporation's contribution. And the employee's contribution is 4,32,000.
Along with it is up to 31/3/2009.
It is
Then
up
after
to
next paragraph
31/3/2009.
2009. But I
Correct.
just taken instruction 31/3/2009. Next paragraph, yearly contribution adding that, the balance come
3,43,000.
here, balance come here. Yearly was 26,898 and their contribution 36, but this is yearly. He worked up to October. Therefore, it is 7 months. Divided by 7 months, it was 37,141. Adding with that, it comes to 7,86,214. And my lord, thereafter, my lord, the interest has been shown here. He has been paid 11,45,444. Last line, page
Extra. This
not
has
extra. Added with the interest. That means my lord, up to his date of retirement 7,86,000. But when he got that amount, interest has been added. That has been shown here, even 11,45,000. He has received that amount. Receipt is here. I'm just showing you lordship. Receipt is here. I'm just showing you lordship. Page 21, forwarding letter. Page 22, the check. And thereafter, he made representations. He sent lawyer's notice. The answer was given to him on when? Answer was sent to him on it is 2025. In spite of receiving that, suppressing this document, yes, file this. But you can also kindly take it from me. It has not been deducted. It has been just shown as it is a taxable income beyond return. If he files return, he will not. If the entire income,
please come. The petitioner is a
Milord,
retired employee of the Food Corporation of India.
Milord, total amount is 11.
He is aggrieved as his employer has allegedly deducted a sum of rupees 3,59,230 on account of taxable interest from his Provident Fund dues. Stop. According to now, prayer has been made to direct the employer to refund the aforesaid amount. Learned advocate representing the Food Corporation of India denies
this is
submission
taxable
of the
interest,
petitioner.
Milord.
Stop.
3,59,000.
It has been submitted that no amount has been deducted from the Provident Fund dues of the petitioner. Stop. The amount is merely the total taxable income after retirement of the petitioner. Stop paragraph. FCI is directed to file a report by way of affidavit disclosing all facts and figures, annexing documents in support thereof. Stop. The calculation relied upon by FCI shall be clearly mentioned in the report. Stop. Such report shall be prepared and circulated within a period of 4 weeks. Exception, if any, within a fortnight thereafter. Stop. List immediately thereafter. Affidavit of service and the notice of completion filed in court be written with the record.
Record that the answer to this lawyer's letter has been given.
You record it in your report and you annex it.
I shall annex.
Call one more minute, please.
Corrected to document.
একটা দিন আপনি
না দেবো না আপনাকে তখন দেবো
সকালে তুমি এসে গেছে পিটিশনার কি বসে আছে হ্যাঁ দেখেছি সেম সিগনেচার দেখে নিচ্ছি petitioner Please once.
No, this is my application, my lord. So the case of the petitioner is this one of the petitioners before Lordship has participated in the selection process which was conducted by West Bengal Health Recruitment Board for the post of homeopathy medical officers. My lord, the entire selection process was, my lord, on basis of interview and, my lord, the marks obtained in their, my lord, in this academic. This was the issue, my lord. My lord, we participated, and, my lord, as per our knowledge goes, my lord, by 19th of May 2025, everything was over. No more further interview was called in. But still date, my lord, nothing is happening, my lord. No results have been published, my lord. Our fate is practically, my lord, is hanging in, my lord. We do not know what is forthcoming before us.
What does the recruitment notice say? How is the result to be published and everything?
My lord,
Is it specified?
My lord, if your lordship takes up page only once, one page, my lord. But if your lordship takes up page 14 once, 1/4. My lord, in between, your lordship will find marks distribution. Lordship has got it, my lord.
Yes.
It says, my lord, academic 70, experience 15, interview 15, written 0. My lord, the interview is all within the month, in the year 2024, 2025, interview is over.
No, I understand. Is it mentioned?
No, my lord, it never shows, my lord.
All right, let me hear. Yes.
My lord, here, my lord, petitioner prayer for publication of results, my lord. My lord, one thing, my lord, my instruction, that's one leave petition is pending before the honorable. That's why I could not.
Let me see.
Last.
Has any stay order been passed for publication of the results?
That I couldn't know. That is, I have to file the opposition, my lord. Last page, my lord, last paragraph.
I will pass an order in case number distribute consequently.
It is a Khali report every affidavit opposition.
Well, this is the OBC matter which our honorable court might has, well, set aside, and that has been stayed. So, well, there is nothing I fail to understand.
Then I have to file my opposition.
And, well, the same very recruitment board is, well, appointing doctors.
Whether the results of the 28 See, what is mentioned over here cannot be a ground for withholding the recruitment process, because other recruitment processes are
the other recruitment. That's why I'm telling madam whether my representation should be considered or my lord the matter should be file affidavit.
You file
Affidavit, my lord.
Yes, Ashunta Dekhi. The petitioner has participated for recruitment in the not in the pursuant to the advertisement number. Please take down this number for recruitment of homeopathic medical officer under the West Bengal Health.
Under the state of West Bengal. Under the state of West Bengal, it's conducted by the recruitment board, my lord.
Yes.
What is this? West Bengal
Health Recruitment Board, my lord. That is the board.
HHH.
Where are your lordship is getting it from?
HHH, West Bengal Health. H12.
Under WBHHS,
homeopathic health service.
Right, WBHHS.
Homeopathic health service. West Bengal Homeopathic Health Service. The process was initiated in March 2024. Allegation is that the same has not concluded till date. The report forwarded by the senior law officer of the West Bengal Health Recruitment Board dated 30th March 2026 placed before this court is perused. It appears therefrom that the process has indeed, recruitment process has indeed not concluded. Stop. The alibi given by the senior law officer is the policy of reservation, which was under challenge before the court. Stop paragraph. It appears that several other recruitment processes are being conducted by the state authority. Stop. A decision ought to be taken by the West Bengal Health Recruitment Board whether to proceed with the said recruitment process or to cancel the same and come up with a fresh one. Stop. The decision of the Health Recruitment Board shall be placed before this court on the adjourned date. Released 11th May. Affidavit of service is taken on record.
Well, the next matter is identical.
Same.
But only difference is that is homeopathic lecturer. Only difference is this, and what
All right.
selection is of 2023.
Let me see once the file. Who is appearing? 17. Who is appearing? 17. Who's there?
17 I am for the state.
Oh, there.
Your lordship will find.
Why are you not concluding the process? It was started in 2023. You have a report with you?
My lord, I do have a RTI reply.
You have?
Same. Yes, my lord. I have made the reply, my lord. There are two replies. One said recruitment is over. The next one says, latter says, my lord, because of this OBC.
Seek recruitment for the post of homeopathic lecturer under the homeopathic education service. ওটা হেলথ সার্ভিস ছিল এটা হচ্ছে এডুকেশন সার্ভিস and recruitment process started in 2023 not concluded.
My lord, your lordship takes up 19.3, my lord. This is the OBC thing. And earlier one, my lord, the RTO reply says
Take a decision. Let the authority take a decision whether continue, cancel, start afresh, do something.
It will be done.
Service is taken on record. Same order will go down.
You cannot say.
Next one is also same.
No, but 17.8. I don't have 18. I don't.
17. It is fine.
Grateful, my lord.
Well, the returnable days, my lord.
11th of May. Yes, what?
18.
18. Who's there? Your other side is here?
Yes, yes, ma'am.
What is it?
Lad, the issue has been finally decided by the Supreme Court. Our division when this the Supreme Court.
What is the issue?
The issue is, lad, whoever lad serving in the junior lecturer post that has been declared as dying cadre, and there has to be upgraded to the post of professor. Now, after acquiring requisite qualification, there is some period was given under the rules. Now, we have all qualifications. Tribunal has already directed to approve us to the post of professor, provided we have this qualification. That has not yet been acted upon. Now, only in the month of
what is your prayer?
Prayer is absorbed to the post of professor lecturer from the post of junior lecturer. Now, kindly takes up straight away to the order of tribunal page relevant part.
All right, what is your stand?
My lord, I am on the maintainability point. Your lordship may kindly have a look to page number 91. Matter is pending before the honorable tribunal. On that point, I am handing over the Supreme Court judgment. My lord, kindly have a look to last paragraph, my lord. Paragraph number 3, my lord.
Yes.
देखिए क्या है? I'm sorry, my lord.
What? Sorry. Paragraph number 3 will be applicable here.
Yes, my lord. Matter is pending.
Matter is pending.
Yes, my lord. Kindly have a look to page number 91 of this writ petition.
What does paragraph number 3 say? Not to entertain petitions regarding constitution, continuation, and composition of tribunal. Is this the issue over here?
My lord, the continuation of a matter, my lord.
Continuation with regard to the composition of the tribunal.
Lord.
This is not the issue over here. Yes.
Number
What is your
page
instruction?
75.
Lord, on merit, my lord, your lordship may kindly have a look to page
Last
number
paragraph.
89.
Yes.
My lord, we have issued a notice to the petitioner, my lord, to in this regard, you are requested to furnish relevant documents, that is the aforementioned essential qualification against your representation within a period of
He has not
7
given
days.
the reply.
No, reply has given, but not given
All
any
documents are with
requested
them.
documents,
From
my lord.
84, I have the qualification. I have
Not
annexed.
Have you annexed your writ petition?
Yes,
with
yes.
Documents. Where are the documents?
Not page 42 and page 29. Experience and my diploma, both I have.
Page
Page 42 is my diploma.
42 and
Page 29 my experience, yes. 43 is also my experience.
Tell me, because I'm going to record over here and I'll
42,
dispose of the
43.
matter.
Well, 27 onwards, all my qualifications that is required.
27 to
27 to 43. Yes.
27 to 43.
Yes.
Are you sure?
Just a second. 27, 33, then?
I can see 45.
No, the diploma qualification I have at page.
I'm ready.
No.
With my lord's kind leave, before my lord's call of the list, my lord, item number 134 fixed for hearing today. My lord, Mr. Sanjay Mukherjee is leading me in this matter. My lord, unfortunately his driver has committed suicide yesterday, my lord. My lord, will it be possible to take up the matter on 8th May, my lord? Because next week I have
134.
134, my lord.
Both
Both parties are present.
be there first. It will start from 132. Let the court reach 134.
My lord.
Give me that
Item number
file.
11.
I have
Yes.
Chief has heard this matter at length. My Lord, very short submission of mine. I'll give my written notes on arguments. My Lord, three basic points that I take here, my Lord. Lordship will very kindly come to page 24 of the writ petition, my Lord. 5368.
একটা নোট ছিল কোথায় আছে বলুন তো Yes, please.
Lordship has had the
Page number
24, my Lord.
24.
Yes.
Yes.
Prayer A.
Oh, the prayer. Yes.
Lordship has had the occasion to go through this, my Lord.
Yes.
Lord, I take this point, my Lord, that they are seeking quashment
Hmm.
of 2 FIRs in a single prayer and a writ petition.
Hmm.
Apart from the fact that there is a legal, efficacious, speedy remedy available to the petitioner by way of revision and by way of 482 CRPC.
All right.
Then your Lordship will. Lord, the second point is the antecedent. Anandapur PS, which has been roped in prayer A, is not even remotely connected to the events which have been reported in Shakespeare Sarani police station.
You are?
Reported in Shakespeare Sarani police station. I am for the de facto complaint.
Yes.
Shafiq and Mamta.
Yes, yes.
But I have said that Anandapur PS case, which is referred to here, is not even remotely connected to the incident of Shakespeare Sarani police station. There are two different sets of facts, two different events, two different dates. But I ask myself this question: how can they be clubbed together for quashment?
All right. Anandapur.
Lord, in my opposition at page 4, paragraph E, I have taken this specific point that this gentleman, Lord, the petitioner, has an antecedent of misrepresenting facts. So much so he had gone to the Supreme Court, my Lord, and got all matters that we had filed against him quashed. When it came to our knowledge, we ran back to the Supreme Court and there all the matters were then restored, my Lord.
Hmm. Hmm.
The perjury is known to him, my Lord. All along he has been doing this.
Hmm. Hmm.
After the restoration by the Honorable Supreme Court, my Lord, he has been trying in different forums, my Lord,
Hmm.
to see that the FIR is quashed. Here he comes up with a writ petition, tagging two different cases together, and in one single prayer, he's asking for quashment.
All right. Do you have any decisions in this support?
Lordship, I can, Lord. Lordship I'll supply it to your Lordship, submit it to your Lordship later,
Do
Lord.
not submit. You have to place it.
Lord, I'll place it, Lord.
Hmm.
These are my submissions, basically.
Hmm.
हम लोग अपने इसमें दिया है ना? Lord, I'll file my written notes of arguments today, Lord.
No little notes. First you place it and then
Lord,
written
I do not
notes.
have the judgments here, Lord.
Then
Lord, I will do without the judgments then. On the facts only, I will submit.
place it.
Lord, these are the three facts that I placed before your Lordship because your Lordship has heard it in length, Lord.
Yes. So you do not want to
No.
make any further submission. All right.
It has already taken.
Yeah, my Lord, the petitioner had taken 8 dates, 4 dates.
So first is alternative remedy which is efficacious available to him. Right.
Secondly, my Lord, it is unknown.
Anandapur PS not related to the Shakespeare Sarani PS. All the FIRs cannot be clubbed together for quashment. And perjury and misrepresentation. These are your points. Very well. Now it will be your reply. Because
In this matter, Mr. Day is leading me. So, I would
next day,
request it to be taken up on the next Friday, Lordship. It will take about a day, Lordship. It will be completed on that.
all right, very well. Please come.
My Lord, I am appearing for the petitioner in another writ petition. Your Lordship is hearing both writ petition together, where my learned friend Mr. Gaffer is not a party to that. My Lord, I actually am returning to Calcutta on 28th. If your Lordship kindly take up this matter on that week, Friday of that week, that will be very much easier because the entire points are related with the basic principles of the writs. It is no more a criminal matter concerned. So we have to answer your Lordship, and we have to answer and clarify. Especially the state has mentioned the Nita Singh case that we have to distinguish.
The Friday that you are mentioning is 1st of May, which is a holiday I can see in the High Court calendar.
My Lord, then your Lordship kindly, may I humbly submit to your Lordship kindly take it up on 8th of May. Because we also need some time to prepare ourselves.
What
State
the
has made a
petitions
lengthy submission.
on behalf of the private respondent.
Petitioner, my Lord.
Shafiq Ahmed and Mamta Agarwal.
Shafiq Ahmed.
Right?
Honorable
Advocate for the petitioner intends to revert with the reply on 8th May. Stop. Released on 8th.
Lord,
Deeply blessed, your Lordship.
I did not find my written notes or arguments. My Lord.
Are those the written notes of arguments? I refuse to accept it.
And my Lord, another thing, if he will file the written notes on argument, he should not be allowed to rely any judgment because he has not placed it in the court.
Your Lordship fixed on 8th at 2 p.m.
It's a Friday, so hearing will be taken up at 2 o'clock.
This was 132. 134 again. 133 on 8.
Yes.
Item 133 on 8. 132 is over today.
133, would you like to make any further submission? They are together.
They are together.
132 and 33, Lordship, they are being tagged.
Right.
133 is only a leaf out of 132.
Whatever.
Same matter, Lordship.
Yes. On the 8th.
Deeply blessed, your Lordship.
ले लो नहीं नहीं छोड़
My lord, item number 134, I appear on
Yes.
the petitioner.
Want adjournment?
My lord, 8th May, my lord.
On the prayer of the learned advocate representing the petitioner, list the matter for consideration on 8th May. But it will be just prior to the vacation. I do not know whether I'll take up for.
Interim order is till 15th May.
Maybe.
Or may, my lord, kindly extend the interim order till the June or fix any date, my lord.
I do not know. Come on, 8th. Let me see.
My lord.
Next. 120 না 320?
320 তো। My lord, in this matter, Mr. Monishan is appearing, my lord. My lord, he is suffering from sleep disc, my lord, so he cannot come today. So kindly take it up next Friday, my lord, he will be here. And the brief is also lying with him, my lord.
On the prayer made on behalf of the learned advocate representing the petitioner, hearing of the writ petition stands adjourned for the day. Who is your other side?
My lord,
Let
AK
notice be served upon the respondents. Next.
In this matter, my lord, I am for the my lord, state respondent, my lord. It was my lord, it was the direction of your lordship that what is the status of the appeal? Similar matter was passed by the coordination bench, my lord. Your lordship granted liberty, granted time to ascertain what is the position. My lord, no stay, my lord, has been obtained, my lord. I told the my lord, learned advocate, my lord, HON'BLE Mukherjee, Amol Sen, Mr. Amol Sen, and they are pursuing the matter, but could not be able to my lord, obtain the stay order. This is my submission to your lordship.
Union of India is not a party.
এটা না 322 monthly list না
None appears on behalf of the petitioners at the time of call.
Well, after election your lordship.
Learned advocate representing the state respondent seeks adjournment. Stop. On such prayer, release the matter on 8th June. Make it in the monthly list of June.
অ্যাপিলটাকে শোনানোর জন্য বিপ্লব your lordship. তাই না
Because in these matters, my lord, Mr. Subhas Jana is appearing for the petitioner, my lord. As he is not present today, I am praying for not today only.
Why is he not present? The matter is there in the list.
My lord, there are 10 petitioners in this petition. My lord. They are making common cause.
Are you there for the Union of India?
I am for Union of India.
328 is a separate matter.
320.
Who is your other side?
Yeah, sure.
I can see DVC's appearance, Shubir Pal and
DVC is the main
Pradip
party.
Palit.
Yes.
Where are they?
Okay.
Pradeep Tarafdar, Shubir Pal.
Subir Pal is the advocate on record.
Call. You can start.
Yes. Okay.
Has opposition been prepared?
Yes. They have
All right.
filed they have filed
Your reply?
the reply also. And all these things were done previously, my lord. This is a change
Yes.
brief. Now, my lord, as I told you, Lordship, my lord, 10 petitioners are making a common cause with regard to denial of pension by the DVC. Lord, the denial is, my lord,
But the opposition is not on record.
not on record. My lord.
No.
We served and we have filed our reply. Reply.
No, it has not been filed. Neither the opposition nor the reply.
That is a change brief. And we got only the copies, my lord. We were under the impression that
It has not been filed. I do
Not
not
been
know
filed.
whether it has been filed in the department or not, but then it is not tagged.
on the records,
Not
in the
with
available.
the records.
Yes, my lord.
Very well, I can accept photocopy of the affirmed copy, provided it is affirmed, and you have to check it whether it is affirmed or not. What is the matter about?
My lord, this denial of pension, my lord, by conversion
Pension.
by conversion from the CPF scheme to GPF scheme, my lord,
Yes.
by the DVC, my lord. And I
Right.
tell you, Lordship, my lord, the facts are like
Did you deposit the contributory provident?
opportunity was not given, my lord. My offer was not accepted. I come to that, my lord. Now, my lord, these petitioners were all in service in the DVC in various capacities, my lord. Some of them were medical officers, some of them were senior managers in various capacities. They served, my lord, the 10 petitioners. Incidentally, my lord, the 10 petitioners have already deposited the requisite court fee. My lord, that certificate is there, my lord, at the time of the previous advocate on record. Now, they retired on various dates between 2008 and 2020. Now, my lord, after retirement of the last petitioner in 2020, my lord, during the 10-year, my lord, they were covered by the CPF scheme, as the Lordship knows, Contributory Provident Fund, my lord. But, my lord, after 2020, my lord, or rather in the year 2020, after the retirement, a notification was issued by the DVC, and opportunities allowed, my lord, to employees retiring between a particular date to opt from the CPC to the GPCs, CPF, Contributory Provident Fund, to General Provident Fund scheme. So that opportunity is denied to the petitioner. Lordship can looks at this order by which were aggrieved and which was earlier challenged. The order is there at page, first of all. At page 61, and type karo copy do. Type karo copy do. Page
66?
61.
61.
Yes. Milord, the
type copy.
we have made a
I
type.
can read it. I can read it.
Milord, the states for some time past, representations were being received from those DVC employees who were governed by the Contributory Provident Fund CPF scheme for allowing them another option for conversion from CPF scheme to GPF pension scheme. CPF subscribers had been given repeated options in the past to switch over to GPF pension scheme. The last such option was given in 2002. Millard, in 2002, all of us missed this opportunity of Millard exercising our option. But still then we continued in service. Thereafter, Millard, this second option is given on 2nd October 2020. Now, second paragraph I'm placing. Corporation, after careful consideration, has decided to allow the existing employees under CPF scheme to exercise and last option to switch over to GPF pension scheme.
Accordingly, all those existing and desirous employees who are members of CPF scheme as on 22/10/2020 shall compulsorily exercise their written option as per the enclosed form and forward the hard copy of the same to the executive director through their respective finance officers by 21/1/2021, so that they are covered under the existing GPF pension scheme of the corporation. Those existing CPF subscribers not exercising the option in prescribed time limit will continue to be covered under CPF scheme. No further request in this regard will be entertained. Option to exercise also needs to be sent in. Similar CPF beneficiaries retiring between, third paragraph, 20th October 2020 to 21st of January 2021, but already opted for GPF pension scheme will be allowed retirement benefits as if they were born on the pensionable establishments. Similar this, we all retired, Milord. All these 10 employees, we retired before Milord becoming.
Which date did you all retire?
We retired on various dates that we have mentioned.
Does it fall within October 2020 till January
No.
21?
Preceded.
Preceding.
Before that.
All right, then.
But the question is, Milord, issue has been decided. I tell you, Lordship, how. Now, Milord, when this was refused to have, Milord, Lordship says, Milord, this was at the height of the corona, Milord. October 22, 2020, at the height of the corona, this was issued. So the petitioners were not readily aware of this. Then, Milord, when they became aware, they made a representation, but that was not allowed. Then, Milord, they approached this honorable court. They filed the writ petition, Milord, and the only question of law which fell for decision as to whether, Milord, they are entitled, Milord, for this benefit of Milord conversion from the CPF scheme to the GPF scheme, since they are all serving employees of the DVC, Milord. So these employees are being given this option, but fortuitously, the fortuitous circumstance they retired before it, but still then, Milord, they're willing to come under this scheme, under the regulation of the, Milord, the DVC, which allows, Milord, based on the modality and allows for conversion to GPF scheme from the CPF scheme. Lordship knows, Milord, this usual method of returning to them, Milord, refunding to them entire.
Then what happened?
Milord, then, Milord, the writ petition was filed.
Yes.
In the writ petition, Milord, the entitlement of the petitioners, in my humble submission, was decided on merits. And Milord, the DVC was, Milord, asked to consider their case, provided they are willing to limit their claim to pension for 3 years only. They were retiring on various dates, but the arrear pension will be limited to 3 years prior to filing of the writ petition. Lordship looks at the order at page 66.
Yes, page
Where,
68, it is mentioned 3 years prior to the date of filing of the writ petition, the same may be considered.
Milord, I'm placing it once more, Milord.
Yes.
My right really flows from this judgment, Milord. It states, this court relies on a judgment of the Supreme Court, Union of India versus Tarsim Singh, reported in 2008 SCC.
I have followed Tarsim Singh. Yes, then what happened? What is the reasoned order?
Now, Milord, the reasoned order which was passed, completely, Milord, that is at page 72.
Yes.
This aspect of the matter was not considered at all. A fresh order was passed. And virtually speaking, Milord, this order appears to be an appellate order, Milord, reversing the judgment of this honorable court and passing an entirely fresh order, not in compliance with the order which was passed. A clear guideline was given that considered the case of the petitioners and to limit their claim to only 3 years arrear pension prior to filing of the writ petition. The clear guideline was given and considered accordingly. Milord, the petitioners appeared, made their submissions. They, Milord, traced the right to this judgment of this honorable court, but still then, Milord, Lordship comes to this operative portion of the order at page 73. What has been considered? Whether at all this is in consonance with the order of the High Court, Milord. Milord, I am placing, Milord, I am not taking much of Lordship's time, page 73, Milord, second paragraph, Lordship comes to the middle portion, Milord. Middle portion, Milord. Admittedly, has your Lordship got it, Milord? The line beginning, admittedly.
Yes.
Admittedly, the present writ petitioners who were in service as on 31st October 2002 did not exercise their option for switchover from CPF scheme to GPF's pension scheme. This is the earlier option which was given in 2002. Therefore, it is clear that the two options were available for the retirement benefit scheme. The writ petitioners to whom the two remedies for retirement benefits are available have the option to elect either of them. But since the writ petitioners had elected not to switch over from CPF scheme to GPF pension scheme in terms of the said office order dated 31/10/2002, is going back to 31/10/2002. By invoking the doctrine of election now, the said writ petitioners, after the retirement on various dates in 2008 to 2020, cannot be permitted in law to claim for switchover from CPM scheme to GPF pension scheme. Besides, the instant case does not come within the purview of the exception as indicated by the Honorable Supreme Court in the aforesaid case reporting 2008 SCC, in which, in as much as since the writ petition has already opted for not to switch over from CPF scheme to GPF pension scheme in terms of the office order dated such and such, as such the claim of the writ petitioners is not based on the continuing wrong. Now, this is a factual misstatement. We missed the option, but it did not specifically say that we were not willing to switch over. Here, Milord, the finding is as if we have refused to switch over. That's not so. We simply missed it. We didn't do anything. So, on this finding, Milord, on basis of this assumption, Milord is coming to this conclusion, and Milord, without any regard for the order, he is examining the claim afresh, as if, Milord, in the order, everything was left at large. When your Lordship, Milord, remands a case, Milord, to the Department for Consideration merits, Milord, the usual expressions used by Lordships are that I have not entered into merits of the claim. The issues are left at large. The department will decide, uninfluenced by any of the observations in this order. Nothing of the sort. Your Lordship looks at the order, Milord. His Lordship was pleased to consider, the Honorable Court is pleased to consider the submission of the division merit. And all the points which are now sought to be asked before a Lordship were asked before a Lordship. That will be reflected in the judgment itself. From the very beginning, Milord, it is a pure question of law to be decided. And Milord, all these aspects of the matter are taken into consideration. After having applied the mind of the court, Honorable Court, and after taking into consideration all the relevant consideration factors, the Honorable Court is pleased to determine me right to receive the pension. Milord, I am once more, Milord, drawing your Lordship's kind attention to these observations, Milord. The court has order of what has got its own sanctity. In the light of the discussions above, this court is of the view. This court is of the view at page 68. So this is, Milord, a definite in my humble submission and the positive, Milord, determination of my right. In a minute, adversarial proceedings, where the respondents are also present.
I lead by Mr. Pradip Torpdar, my lord. He is out of station, my lord. Keep it in another day, my lord. Kindly.
Where is your opposition?
Opposition is ready. I have already served, my lord.
Yes, but it is not filed.
Not filed, my lord. Next day I filed. Already affirmed, my lord.
Please come. Submission.
Reply.
Is photocopy of the affirmed copy?
Yes. No. That is I have served, my lord.
No, I'll tell you, Lordship, the date of affirmation is yes, it's mentioned here. It is your
hot submission made by the learned senior counsel representing the petitioners. Stop. The original affidavit in reply is readily not available. Stop. A photocopy of the please stitch it. Yes. Please stitch it.
I'm sorry, may apologize.
Let a photocopy of the affirmed affidavit in reply be filed on the adjourned date. Stop. Learned advocate representing the respondents seeks accommodation. Stop. List on Next Friday 24th.
Next Friday 24th.
এটাকে একদম উপর দিকে দিয়ে দেবেন। এটা একদম হিয়ারিং এর ফার্স্ট ম্যাটার, উপরের গুলো তো কিছু হচ্ছে না, সব অ্যাডজেন্ট হয়ে গেছে তো। সো উই স্টার্ট অফ উইথ দিস ম্যাটার, তাই তো? হিসেব তো সেটাই বলছে।
সাপ্লিতে দিয়ে দেবেন না?
Please wait, you do not advise my officers. The court is here to take care how to manage the list. As it is becoming very difficult.
Sorry, ma'am.
And then if you all dictate terms as to how list
Madam,
is to be
sorry.
prepared, then it is impossible to run the court. Right? Please check up. Yes, this is a continuing, it's a continuing matter. We'll finish it off. Please come ready on the next day
Yes,
so
yes,
that it can
ma'am,
be
yes.
finished.
Milord, is it your lordship's pleasure to mark it parted, Milord, for today?
Why? Next Friday it will be
Ben,
taken up.
Ben, as your lordship pleases.
Yes. No,
Member petition, Malad.
Yes.
Milord, we shall leave with your lordship's officer after stitching it.
Next Friday, file it, no difficulty. Stitch it and file it next Friday. And in the meantime, if you get the original, then you can come.
Well, I'm for the petition, Malad.
Yes, who is the contemptor?
Pradhan is the contempt, Malad. I am, according to my direction, Malad, I have subbed the foolish to all. Can see it, Malad. With the website copy of the order, Malad.
Yes. Yes.
In spite of the order, did not appear, Malad. In spite of the direction, Malad, I have subbed all, Malad, that it will appear and everybody should be present, Malad. But it is related to Malad, unauthorized construction, Malad. And Pradhan did not consider it, hence it is contempt petition has been filed, Malad.
Part demolition has been
Yes,
done.
part Malad.
Fully it has not been demolished.
Not done, Malad.
And what is the stand taken in the affidavit of compliance?
Thereafter, my lord, there is a dispute between the facts, my lord. That's why my lord directed the BLR to submit a report, my lord. But that they filed two reports, my lord. I filed exception to this report, my lord. Well, earlier first report support my case, my lord. Another report they reverse the matter. But with the connivance of the Pradhan, my lord, they change the report, my lord. That's why, my lord, kindly see my exception to the report, my lord. I've said everything, my lord. Well, interesting fact, my lord. The private school already admitted this fact, my lord. My case, my lord. They admitted that there's by mistake they acquired some government push land and they made some construction, my lord.
Identified as both rounds in front of this place. Who has made unauthorized construction? Is it the panchayat?
Private respondent, my lord. Well, kindly see the report of the 17th March, my lord. First report. Well, there's an inquiry report.
17th March, yes.
Inquiry report filed
Yes.
by the revenue inspector to the
Right.
BLR, my lord.
Yes.
He already supported my case, my lord. যে ফাঁকা জায়গা উক্ত পঞ্চায়েত বা এলাকাবাসীর কারো কোনো ক্ষতি না হয় বিবাদীগণ সাবমার্সিবল পাম্প চেম্বার কয়েকটি গাছ লাগাইছেন, এখানে এলাকাবাসী যাতায়াতের কোনো অসুবিধা হইতেছে না। অদ্য তদন্ত অনুযায়ী অপর মৌজা হয় এই because there is no objection to the other villagers, they acquired the government land.
And this is the report of the revenue inspector, Manas Kumar Bandyopadhyay. Thereafter, my lord, they filed another report, my lord, another report, BLR, my lord, and he already said another thing. And they also, private, there is also a statement of the private respondent, my lord. Kindly see the page, my lord. 4, my lord. Their daughter and wife admitted that. আমরা ভুলবশত ওই তাকে উত্তর দক্ষিণে জমির মধ্যে সাবমার্সিবল পাম্প, পায়খানা চেম্বার ইত্যাদি করিয়াছি, কারো কোনো অপারেশন হচ্ছে না। সেটা ইজ দ্য স্টেটমেন্ট অফ দ্য ওয়াইফ এন্ড ডটার অফ দ্য প্রাইভেট রেসপন্ডেন্ট, my lord. Well, that's why, my lord, we state that.
What is your plot number?
My plot number, just adjacent land, my lord. Actually, no dispute between my land. Actually, land becomes narrow, my lord. And we travel to run a pump set, tractor like this, my lord. And four-wheelers do not run easily, my lord, because the road become narrow, my lord. This is my difficulty. Directly, they have not acquired my land.
And the construction which has been made, is
yes,
it over any government plot of land?
Yes, my lord. Yes, my lord. This is Panchayat road.
It's a Panchayat
They
road.
admitted that, my lord. It's a report of the revenue inspector and the statement.
But the diagram that has been shown, it shows that the Panchayat are nirmito pod, but there is no construction thereon.
My lord, main building is within that land, my lord. And thereafter they made submersible pump, chamber of the privy, my lord, etc. And they planted tree, my lord, in the government land, my lord.
Planted trees?
Planted trees and made chamber of the privy and tube well, etc. in the Panchayat road. The road becomes narrow. And there is own admission of the private wife and daughter.
Where?
Yes, ma'am. Kindly with the first report, ma'am, 17 March, filed by the BLRO.
March, yes.
17 March.
Right.
In the page number 4, my lord.
Page number
this
4.
Is the statement of the wife and daughter of the private respondent, my lord, and we along with the other villagers.
Which portion?
Well, kindly page 4, my lord.
Page 4 at the bottom.
From the running, my lord, 12 March তারিখে বেলা 12টার সময় BLRO. Kindly.
Yes, and where is it recorded?
Yes, last portion, my lord. Last portion
at the bottom.
Few lines. আমরা ভুলবশত একদম last few 4 lines, my lord. 4 or 5 lines. আমরা ভুলবশত রাস্তা 621 নম্বর দাগের মধ্যে যাহা উত্তর দক্ষিণে 47 ফুট ওই জমির মধ্যে শুধু সাবমার্সিবল পাম্প এবং পায়খানা চেম্বার এবং বাসগৃহে ইভেন বলছে বাসগৃহে ছিটে ফোটা অংশ পড়তে পারে বলছে, along with the other witnesses of the village, my lord, in presence of. After the filing of the compliance report of the Pradhan, my lord, this has been done.
Please come. None appears on behalf of the respondents. Respondent/contemptor. Stop. Let notice be served upon the learned advocate representing the respondents/contemptor.
Advocate of the Pradhan refused to accept, my lord. That's why I sent it post. Can you see my letter, my lord?
Advocate of the Pradhan refused to accept.
That's why I send it through post, my lord. Speed post, my lord. Can you see my letter, my lord? I've served all.
All right, you serve Mr. Srikanto Pal.
He's already accepted, my lord. In spite of that, he did not appear, my lord. Actually, my lord, Viola has nothing to say, my lord. He intention know it that they filed 2 reports. One is refers to other.
Upon the learned advocate representing the Blockland and Land Reforms Officer. একটা কাজ করুন, serve to Mr. Srikanto Pal, learned advocate, representing the Blockland and Land Reforms Officer. Released next Friday.
My notes,
yes.
It will be on record. Yes, madam.
Let the notice of the learned advocate for the petitioner served upon the learned advocate representing the respondents and upon the Pradhan.
Yes, my lord.
And the private respondent be written with the records. Was anybody representing the private respondent? No, never.
Never.
Very well. Next.
Then only must have to state advocate, my lord. Only to
yes, state.
Yes, my lord. In this matter, my lord, I beg to appear on behalf of the alleged contempt. My lord, we have filed an affidavit of compliance. It has been complied with. And my lord, I have stated in paragraph 12, they have given promotions to the as an inspector. As to the other aspect, my lord has kept it open. If your lordship kindly comes to my lord's order.
1 minute. Record his presence and dismiss the contempt for default. Last occasion they were not there. So petitioner is not appearing on repeated occasions. Dismiss for default.
Much of same. Next is also
31 also same?
Same.
All right, same.
Matter.
332 হয়ে গেছে? All right, 333. It's an assigned matter.
I appear for the added respondents, but I am praying some time to file my written objections. But this was once dismissed by my lord, went up to the division bench, the Honorable Chief Justice. There, I asked to be added. They added, they have served copies long back. I'm admitting, in November I have received the copies, but I have due to lack of instructions, it could not be prepared. But I'm praying 2 weeks time, I shall file it on the next day. I've just
this matter, my lord. I am for the petitioner in this matter.
Yes.
This is a police in action, madam. There are suits pending, 2 suits pending. There's an order of injunction.
No, my lord, that is
the honorable court. I shall
kindly
satisfy on all those points. But kindly,
you are Showman Kole?
Showman Kole.
Private respondent?
Private respondent.
Time was given in September 25.
Yes, it was given, I apologize, it was given, but I have just now received instructions, long time, we did not receive any instructions to the effect.
If the client is not concerned,
no,
why will you?
No, concerned, just now, I have taken instructions. Kindly, 2 weeks time, I shall come back with the report. I serve in the meantime.
What is the matter about?
Malad, the matter is, Malad, the petitioner made a complaint before the complaint police station. Not only that, I am holding the secretary of the KBSK, Malad. Now his client, my lord, has lost the matter before the city civil court. By suppressing the material fact, when the matter was taken up for hearing, he has, in a piecemeal manner, he is saying he is the secretary of the concerned organization. Subsequently, my lord, since in the very first instance matter was dismissed, my lord, I prefer an appeal before the division
what
bench.
is the issue to be decided in the instant writ petition? Tell me.
The issue is decided by the private respondent fraudulently disturbing our organization, and he is restraining us to functioning as the secretary of this organization. Therefore, I made a complaint before the police station. Police did not take any action.
What type of action can the police take? There is a civil pending, you say? Why don't you get your right decided by the civil court?
No, this is not a case of civil suit pending, my lord. I shall satisfy your lordship. Let my learned friend come with a proper instruction. My lordship kindly fix after 2 weeks, my lord, I shall satisfy your lordship.
You are not able to satisfy the court now. How can you satisfy after?
My lord, actually, my lord, I am representing the National Company Law Tribunal. BP is not with me. Kindly accommodate for this. No, I could not come to the High Court.
The respondent number 7 seeks extension of time for filing the affidavit in opposition. Stop. On such prayer, time to file the affidavit in opposition stands extended till how soon?
2 weeks, madam.
8th May.
Grateful.
Release the matter on 8th June.
Grateful.
Affidavit in reply may be filed prior to the urgent date of hearing.
I'm so grateful.
Grateful.
Next. Dismissed.
Certified, my lord, I appear for the petition.
Yes.
My lord, this relates to, my lord, non-granting of promotion and, my lord, the issues, my lord, that I've been deprived to, my lord, to get promotion, my lord, with a retrospective effect. Now, before your lordship takes up my lord's brief, may I, my lord, give a very short summary. And, my lord, I had joined.
Did you complete the minimum time period
Well, that is my
for
case.
being eligible for to be considered for promotion?
Well, that is my case.
Yes,
that is my
please.
case before your lordship.
Place it. What was the eligibility criteria for being
My lord,
considered for promotion?
my lord, so far as the eligibility criteria to be considered for promotion, my prayers and the issues that may be boiled down for my lord's adjudication is this, that whether the promotion that being granted to me to be considered from an anterior date or from the date which was actually been given due to the lack of the administrative failure. That is failure. There are specific, my lord, contemporaneous records which would per se show that I, being, my lord, an eligible candidate and successfully completed the previous round of examination and being, my lord, emerged as successful, but could not take place because of the cancellation of this those election of those examination, my lord, because of administrative lapses. And there are specific issues which were, my lord, followed previously by the administration, and, my lord, a proper, my lord, a benefit was given to me, saying that since, my lord, these periods were lapsed not due to my fault but due to somebody else's fault or some manipulation which was done by the other candidates, not by admittedly by me, so the promotion ought to have been, my lord, given from a retrospective effect, and that would give me a leeway, my lord, to, my lord, appear for a subsequent promotions. Now, my lord, so far the very checkered facts of the case is this, my lord. I, being a constable, my lord, appeared for the post of promotion of ASI. Now, my lord, in the post of promotion of ASI, my lord, I stood successful and I...
It's better we start on the next day
Very
because
well,
it's nearly 3:30.
Very well, sure. Whenever it commences, my lord, I shall...
Friday, it will be remain in the list.
Very well.
Same position.
Deeply grateful.
We'll start.
May your lordship, my lord, please enough to record an order, my lord.
Learned advocate for the learned senior counsel representing the petitioner commences argument. Stop. Due to paucity of court's time, a hearing cannot be concluded today. Stop.
Extremely grateful.
List the matter on 24th. List.
Would it be lordship's kind wisdom to written as a monthly list or, my lord, daily?
Check up the list.
Whichever commences, my lord. 24. For my lordship.
Deeply grateful, lords.